We are recording. And then court cry. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. We are self-evidently conducting our arguments this morning via video conference in light of the difficulty created by the ongoing pandemic. And we're grateful to the Office of the Clerk of the Court for their assistance in making this technologically possible so that litigants before us may make their cases orally to us and present their arguments in the best way possible given the circumstances, and so that we can get our questions answered by counsel for the litigants in order to try to assure the quality of the decisions that we render. Our first case this morning is Commonwealth versus Branch, number 19-1304. The rules of argument are the same as they are in the courtroom, which is to say 15 minutes aside and there is no rebuttal. Because this is via Zoom, there can be a little bit of lag time. People may talk over each other a little at the beginning of questions or answers, so you should just be aware of that, and we will take this as it goes. We will hear first from Ms. Nocum, and the time is yours. You may commence at your readiness.
Good morning, Your Honors. As Your Honors are already aware, the appellant defendant has conceded 2 of the 3 issues, as the Commonwealth correctly noted that the 209A violation and malicious destruction to property, the defendant had pled guilty subsequent apologize for those indictments out of Middlesex Superior Court. So the only remaining issue is with respect to the assault with a dangerous weapon. I would first address whether the court found good cause to dispense with Mr. Branch's right to confrontation. And the only testimony that the Commonwealth offered in that regard was the probation officer's testimony that he made numerous, several, or multiple phone calls to the witnesses, and that he generally went by the home or the home in Malden number of times, and that the probation officer received information from the assistant district attorney from Middlesex County that Ms. Sharon Boyce had invoked her 5th Amendment privilege. Those records were, the 5th was invoked pursuant to Martin, so those records were not available according to the records. So what I would say to that is there was no testimony regarding any other attempts. Clearly, the case had been open with Middlesex County for quite some time. There would have been a victim witness advocate and an ADA assigned to handle the matters. There was no effort to try to find, for instance, either of their employment. There was no evidence to suggest or indicate what time of the day, for instance, that the probation officer went to the home, or what time of the day the probation officer called the witnesses. It could have been that the parties were working and the probation officer or the police that went by the same exact time. I suggest that the attempts are woefully insufficient to do away with good cause with respect to Mr. Branch's confrontation rights.
What is our standard of review for this argument?
Your Honor, I believe the standard of review is abuse of discretion for purposes of dispensing with.
So I guess what you're saying then is, as a matter of law, the judge was required to reject this explanation of the efforts that were made to locate these witnesses and to conclude that they were, as a matter of law, inadequate?
Well, what I would say is that the judge has broad discretion clearly, and that she abused that discretion by finding good cause where there was insufficient evidence to established that the Commonwealth made their case that there was good cause to dispense with Mr.
So
Brent.
where would be the line? In other words, where would be the line where that would show that these efforts were inadequate? This was not good cause, but that something more would have been. I mean, you would agree that the test is not no stone need be left unturned.
I would agree with that sentiment.
Okay, so as part of me, when I hear your list says, oh, what you're advocating for is no, every stone needs to be turned. So please explain for me, if you wouldn't mind, how we would test that the judge misapplied her discretion in this case, and what would have been necessary for this to be a valid exercise of her discretion.
Well, I don't know if I would suggest that there be a bright line rule as to the number of attempts, say, or the number of times during the day, or which times during the day that vary, for instance. What I could say in this case is more could have been done reasonably, because I think that the information would have been readily available to the police and to the probation officer with respect to what other efforts could have been done to procure these witnesses, particularly where the cases have been open. Well, the case had been open with Middlesex County District Attorney's Office for quite some time. So they would not have been the only parties who would have either attempted or had access or at least communicated once or more with these witnesses. So I think what is more telling is what wasn't done, not so much what was done. The generalities were offered. I suggest that that's all that it was. I made numerous phone calls. I believe Officer January even said, I can't even count how many voice messages I've left. I suggest that's also a generality. We went by the house a bunch of times. I got the Malden police officers involved and they went by. Also generalities. We do not know. We do not know how credibly and reasonably.
Why wouldn't, let's say that it is too general. Let's take numerous to mean 3. 2 isn't numerous. 3 probably isn't either, but let's call it 3. You think calling and leaving voice messages 3 times is inadequate?
I would say it is inadequate under these circumstances. We also don't know, were the calls made midday? Were the calls made?
Voice messages were left.
I understand, Your Honor. I think that timing would still be critical. And
I assume you're arguing about availability of witnesses because you wanted them available to confront them?
That's correct, Your Honor.
I understood your brief at pages 21 to 22 to be acknowledging the holding in Durling that the constitutional right of confrontation can be dispensed with if the proffered evidence bears substantial indicia of reliability. So assuming if the judge were correct in holding that the hearsay admitted here were substantially reliable, then wouldn't the efforts that were made or not made to find Ms. Boyce and her son be more or less irrelevant?
Well, I think that my argument also goes toward the fact that the evidence that was submitted does not meet the Durling requirement. What they had,
Go ahead, sorry.
Durling does require good cause to dispense if the surrender judge was only going to rely on hearsay evidence. In this case, that's what the judge in fact did. Exclusively the whole surrender.
Is that right? Does the evidence that might come in as excited utterances, that is evidence within the hearsay exception, which is to say evidence admissible at a real trial, does that count as hearsay, or that's not hearsay within the meaning of this sole reliance issue?
Well, Your Honor, I think in this particular circumstance, as trial counsel argued under Beatrice, and surrender judge admitted the statements under Beatrice as spontaneous utterances, I would distinguish this case quite starkly with Beatrice. One, under Beatrice, the victim had just fled her apartment to a neighboring unit. The defendant, who had just viciously abuse her was still in the apartment, certainly in the building, leaving her still in imminent danger. So when we're referring to these statements that came in for Ms. Boyce and Mr. Boyce, taking first, say, Ms. Boyce's statement, she was safe in her home at
Okay,
that
but
time.
now you're saying something different. I asked you if, I didn't quite say it this way. Let's assume the judge was right that these are spontaneous or excited utterances. Does the rule about solely on the basis of hearsay apply or not apply?
If the surrender judge correctly found that this was an exception under Beatrice and excited utterances, then Your Honor would be correct.
It does not apply.
I do not dispute that, right?
Okay. No, well, that's just my question. I mean, now you're arguing, and that's fine. Also, of course, that these weren't properly admissible as excited utterances.
Yes, Your Honor.
Mhm.
So returning to Ms. Boyce's alleged statement, as I said, she was safe in her home. Her son had already chased Mr. Branch out of the home. And by the time that the police had arrived, there was no imminent danger to her. She may have been upset. I think one of the officers even said that she
Does the danger need to be to the caller in order for it to qualify as an excited utterance? Could the danger be to another person, but the caller is witnessing it, or is right in the middle of the entire process and be sufficiently excited for the statement to qualify?
Well, Your
I
Honor,
mean,
that was going to be, I think, part two of my argument. And I have to confess that I was unable to find anything directly on point with respect to whether somebody would qualify under Beatrice, say, make statements pursuant to Beatrice, who is not the underlying complaining witness or victim. Moving to Dominic Boyce's statement, his 911 call was admitted despite the fact that the surrender judge would not allow the police officer to testify as to the contents of the statement. I don't know how logically that made sense, but in any event, it happened. Also under Beatrice, the surrender judge admitted that 911 call. Here, it cannot be said that Dominic Boyce was the victim. He was in fact chasing Mr. Branch away from the property and repeatedly declined to identify himself. I think that is a significant factor in this.
Is there any case that requires someone making a spontaneous or excited utterance to identify themselves, or that they even be identifiable by anyone else?
Not necessarily, Your Honor. Certainly not one that I find, but I would say that I would liken maybe Mr. Boyce's circumstances to cases involving informants or somebody who makes a confidential phone call. I think that there's more reliability.
I don't understand your hypothesis. The judge found as a fact that this was the victim on this call. In order for it not to be the victim, we would have to conclude, in order to find that clearly erroneous, I guess, we'd have to conclude that in, I think it was Malden, in this area, at this time, two people took a swing at a victim with a screwdriver. That seems most unlikely, doesn't it? That is at least unlikely enough that it's hard to say it's clear error to conclude that the guy calling on the phone saying he took out a screwdriver and swung at me and tried to stab me is the person referred to in the other call, where someone has called up and said, this guy took out a screwdriver and went for my son.
Your Honor, I think that I don't know if that's the direction of the analysis. It's whether or not that those calls and statements should have come in at all, and whether the surrender judge say the 911 call was excluded. What other basis would the surrender judge then have to rely on that the assault with the dangerous weapon occurred? So I think the analysis is the admissibility itself, not so much the likelihood. So he's in the vicinity. I don't think that Mr. Branch being in the vicinity of the home is any indication of what had occurred at the home.
I'm sorry, I don't understand. The caller said, are you saying it's not an excited utterance or it's not Mr. Branch? I mean, not Branch, the victim.
Mr. Dominic Boyce.
Yeah.
What I'm saying is that there's no identification made, and I don't think that's.
Oh, I see. So it may have been someone else who swung the screwdriver.
Your Honor, I think that's. I'm finding it hard to articulate, I think, my position, and I think I'm just being inartful. What I'm saying is that without that tape, without that recording, that the surrender judge would have not had sufficient evidence to find that Mr. Branch was the person inside the house, or that Mr. Dominic Boyce was in fact the person who.
So even without the tape, both Ms. Boyce and her son Dom recounted to Officer DiCarlo at the scene what had happened, and they both gave quite detailed accounts that were very consistent with each other, right down to throwing the wallet on the table before Mr. Branch left with Dominic in pursuit. So putting the 911 calls aside, aren't there fairly detailed and contemporaneous accounts recorded in the police reports and recounted by the officer on the stand, themselves substantially reliable hearsay that would support the finding of violation?
Well, Your Honor, I believe that that's only one factor in the analysis. Durling requires more.
What more than substantially reliable does Durling require?
Well, at least in Durling, the court decided that because those police officers were precipient in their ability to view the events as they were occurring, that there was some indicia of reliability. That they also, and in other cases I cited in my brief, that in instances where the police observed other objective indicia to corroborate the detailed stories or accounts that were being told by witnesses. I think here, we don't have that. We have, undoubtedly, the police went to the house, they got accounts from both Mr. Boyce and Miss Boyce, but no other indicia, no other corroborating evidence, I suggest, to meet the standard as required by Durling.
Okay, your time has expired. If there are no further questions, thank you very much. Very good argument. We will hear now from Ms. Jang.
May it please the court, Kristen Jang for the Commonwealth. If this court has any questions about the first issue here, the mootness issue, or my motion to expand the record, I'm happy to answer to that, but I know the defendant has conceded the mootness issue as to 2 out of the 3 issues on appeal. So seeing no questions, I'm happy to move on to really the only live issue here, which is whether the record amply supports the reliability of the hearsay evidence presented here as to the assault with a dangerous weapon charge.
Can I ask, is good cause a separate prong from reliability? Do we have to get through a good cause prong, or are they somehow interwoven? I don't remember, but I remember case law suggesting that something amounts to good cause, that at least in prior cases, I don't remember focusing on it so much. So can you clarify that for me, please?
Absolutely. So I cited in my brief the Nunez case, that's 446 Mass 54. Under that case, if reliable hearsay is presented, the good cause requirement is satisfied. So really all we're focusing on here is whether the hearsay evidence presented was substantially reliable or not. So in my brief, I kind of took each piece of hearsay evidence separately and looking at the reliability factors as to each piece of evidence. So really the first piece that we're looking at here is Dominic Boyce's statements to Officer DiCarlo on the scene. And I went through a number of factors that speak to the reliability of those statements on the scene, including the fact that he was the victim here, so he was the one that personally experienced the events. His account was consistent with both 911 calls. He was apprehended just a block away from the Malden residence. The history of the relationship between Dominic Boyce and the defendant in this case.
May I interrupt you there and ask
Absolutely.
about the finding that the judge made that and I'm looking at page 5 of the second day of the hearing. She says, the police located the defendant exactly where Dominic said he would be found in the second 911 call. I didn't hear him saying on the 911 call, I'm on Barstow Street, here's the defendant, or anything identifying exactly where the defendant would be found. Obviously, they were in the same general neighborhood. It was the same streets that kept getting mentioned, but I didn't hear the defendant. I didn't hear Dominic mentioning Barstow. So is there support for that finding?
I believe there was testimony. I agree with you, Your Honor, that I didn't hear the exact street address on the tape, but I believe there was testimony from the officer that he was found exactly where the caller.
There was a reference on the tape to a particular street, but Dominic couldn't give the street number.
Correct. He was calling out a bunch of streets, a bunch of numbers. It was very chaotic. Obviously, he was running, so he was out of breath. So that kind of contributed to the confusion. But I believe that there was testimony from, they had been Officer DiCarlo, and I apologize for not having the site to the record, but I believe there was testimony from the officer.
That Dominic identified the street?
That the defendant was apprehended in the place where that 911 caller had said he would be.
I do recall that Dominic on the tape gave the street location.
He did give a street location. He was
but
throwing
not a
out some
street
numbers.
number.
Right. He was throwing out some numbers at various points, but he was moving too. So his location was changing as well. And as to that anonymous 911 call, I would submit that it does fall under the excited utterance exception. And as to the back and forth about a piece of hearsay falling under a hearsay exception in a probation violation hearing, under Durling, if a piece of evidence falls under a hearsay exception, it's still hearsay, but it's considered presumptively reliable. So in this case, I submit that both 911 calls really fall under the excited utterance exception. The issue we're looking at is whether the declarant made the statement under the stress of an exciting event, which I would submit that being attacked by a screwdriver and then pursuing the person outside of your house through yards, over fences is an exciting event. In this case, Mr. Boyce was still under the influence of that exciting event because he was still in pursuit of the defendant in this case. And certainly he didn't have the opportunity to contrive or fabricate any part of that statement, which is the whole point of the excited utterance.
Do we need to determine whether there was an ongoing emergency here?
No, and I didn't write down the case, but in one of my footnotes, I cite a case that says that you don't have to get to the confrontation clause analysis when you're talking about a probation revocation hearing. It's in a footnote. Here we go. So on page 40 of my brief, footnote 35, it's the Wilcox case. It states that claims under the Crawford v. Washington case and its progeny are not applicable to probation revocation proceedings. So really all we're looking at is kind of that first step in the typical analysis you do for excited utterances. You're looking at whether there was an exciting event and whether the declarant was still under the influence of that exciting event. I think the Robinson case is very interesting here. It's a good corollary. In that case, the victim had been attacked. The defendants ran away. His brother came to help him, and the victim actually went to chase down the defendants into a building. Police came. Police dragged out the defendants, and the victim / declarant in that case said, "Yep, those are the guys." So in that case, the defendants were already apprehended by police. His brother was there to help him. He even went to pursue the defendants in that case. And it was still considered an excited utterance because he was still under this purview of a startling event. The same kind of analysis applies to Sharon Boyce's 911 call. The timing of the call coincided with the other 911 call. Her report was consistent with what she said on the scene and was consistent with what Dominic Boyce said on the scene. And then as to her statements on the scene, it was a fairly detailed account. It was consistent with the history of her relationship with the defendant. And also the restraining order that she ultimately obtained against the defendant was entered into evidence. So that just further corroborates what had happened here. I'm happy to answer any other questions, but seeing none, I will rest on my brief.
No further questions. Thank you very much. Another very good argument. Nice job, both of you. Thank you. The case is submitted.
Thank you, Your Honors. Good day.
Okay, good morning and welcome to the Appeals Court. We are sitting self-evidently by video conference in light of the ongoing pandemic. The next case we're going to hear is number 19-1795. The rules are the same as they are in our courtroom, which is to say 15 minutes aside with no rebuttal. I should caution counsel, your cameras are on and will remain on throughout the proceeding. Your microphones may or may not be on at various points, but I would act as though they are on in case they are. The video of this is now actually streaming live on our YouTube channel. It will also be archived and available for public viewing. So with that, our next case is number 19-1795. I'm sure I'm going to mispronounce this. Commonwealth versus Guamandui. And we will hear first from Attorney Rubin.
Thank you, Your Honor. May it please the court, I'm Eric Rubin and I represent the defendant, Mr. Guamandui, in this appeal from his conviction at trial for operating under the influence with a suspended license, that license suspended for operating under the influence. In this case, the Commonwealth's closing invited the jury to interpret the defendant's silence as cooperation as evidence of guilt, and therefore created a substantial risk of a miscarriage of justice. This case has a very simple fact situation. I think my brother and I are in agreement about almost every aspect of this case. There is a single witness for the Commonwealth, a single witness for the whole trial, which is the arresting officer. He sees a car going the opposite way. He judges that it's going a bit too fast. I believe at different points in his testimony, 5 to 10 miles an hour. He has no idea who's driving. He never gets the license plate. He doesn't even know. He thinks there might have been a passenger. And the next time after he follows the car and makes the turn, he sees a car that he thinks that's the car in a driveway, stopped with my client in the car.
I thought your client was already standing outside of the car at the point.
That may be accurate, Ron. I apologize.
And I thought the officer testified that it was the same car.
Well, my memory is that he believed it was a white Chrysler, but he did not get the license plate. He could not determine the speed and he could not determine the driver or if in fact there was a passenger or not.
But it seemed like there was, presumably one can infer from the location of your client that he had just gotten out of, or maybe was just getting into, but had just gotten out of the car. So here's a car, it's, I don't know, 10 seconds or something after the officer last saw it, and a driver has just gotten out of it. It's the same color, it's the same make, if not, maybe we don't know beyond that.
Well, I'm not contesting.
Why is that an unreasonable inference for a jury to draw? I guess that's the same car.
Right, Your Honor. And I'm not saying that in and of itself is an unreasonable inference. However, the fact that he stops that vehicle, my point is that this is not an open and shut case. And the reason I want to make that is because when I'm doing the substantial risk of a miscarriage of justice standard, we're going to look at that. So why don't I, if it's all right with the court, go right to the statement in the Commonwealth's closing that both my brother and I know is the heart of this appeal, which is in the argument, the Commonwealth states, and I would suggest he was and again, it was silent and cooperative, because he knew he was driving, and he knew that he had
Wait. You've added the word silent. What does the prosecutor say exactly, please?
Well, I'm sorry, in the preparation for it, he talks about him being silent and cooperative.
Silent
Correct.
and cooperative, or cooperative?
Cooperative, but I believe he also talks about his silence.
I think he said he didn't protest.
Okay, thank you. He didn't protest, and he's cooperative.
He wasn't silent at all.
Well, my memory is, Your Honor, that he said that he was coming from the club.
That's right. He spoke. Right. He was not silent at all.
Right.
And what he said was not, I don't know what you're talking about, or I'm just out here getting something out of the car, or what do you mean coming from? I wasn't driving a minute ago. He didn't say any of those things. But that's not because he was silent. It's because what he did say is not what one might have expected if, in fact, he had no idea why an officer was asking him to do anything. I just don't see this as a silence case, frankly.
Okay.
Maybe I'm wrong, but go
Well,
ahead.
let me ask you this. If it's not silence, what we're asking then of a defendant is there is a duty then on the defendant, according to what you're saying, say he's not silent, but he must have some kind of response or script in response to a police officer of a
I think perhaps the notion is that when the defendant chose to speak and offered whatever he offered, then it's fair game to say, well, he said A, he didn't say B. And the defense at trial was that this was not the right car, this was not the there was no way to know that this was the car that the officer had seen. And so if that's the defense, then why is it that the prosecutor cannot comment on the fact that when this particular defendant pulled over, he didn't say, he said, I just was driving from whatever the name of the place was, I forget.
The Portuguese club.
I think.
The Portuguese club, right? So he doesn't deny driving. He gives the location from where he was driving. So why is it that the prosecutor can't then, in those circumstances, say he didn't protest? By which, you mean he didn't say, I wasn't driving, I'm just standing here having a smoke next to this car in my own driveway.
Right, Your Honor, I understand. Then the question is, what duty does a defendant have to launch a defense and start to speak with authorities rather than use their right under the Fifth Amendment Declaration of Rights, where they're allowed to not say anything? And
right,
then,
but
wait.
He didn't do that.
Let's take a routine case. He confesses. He doesn't have a duty to not confess. You go to a guy, you say, did you just shoot that guy? And instead of saying, what guy? I don't know what you're talking about. I was just reading this book here. He says, yeah, I did. And the prosecutor says, surely he wouldn't have said, yeah, I did, if he didn't. Isn't that just this case? I mean, I get that it's this has this slight sense of not protesting, but to me, it doesn't seem, there's no silence involved. I don't think it's a question of what is the significance, what can we infer from what he did say?
well, Your Honor,
Infer from what he did say is he was just driving from the Portuguese club.
surely,
To
Your
his
Honor,
home, which was someplace else.
surely,
That's what he said.
surely there's a difference between the admission of a crime and just not admitting, but saying something. It seems to me, Your Honor, in your hypothetical, that there's a clear admission of a crime, and then there's going to have to be some type of justification for the crime. Here, there is no admission of a crime.
No, but there is an admission that he was driving moments ago from the Portuguese club. That's what he says. So isn't that an admission that this is indeed the car that the officer was following from near the Portuguese club until it made this turn? I just don't, I mean, I see what you're saying, but I wouldn't frame it as having a duty or anything else. He did speak, and what he spoke revealed, because it didn't include statements like, I wasn't just driving, or what are you talking about? Or I was coming from Brookline or something in some other direction. He said he was coming from right where the officer thought he was coming from.
Your Honor, what about the statement, he knew he was driving and he knew that he had too much to drink? And
I don't know about that statement. Now you're saying what, that that's not supported by the evidence?
Well, Your Honor, saying, and he knew that he had too much to drink, is that fair argument in an operating?
I don't know, but that's not, your argument is silence, at least as I read your brief. Your argument is not, I don't see, maybe I missed it, but I didn't see an argument in your brief that that phrase shouldn't have been included. I didn't think that's what we were talking about.
Well, I understand, Your Honor, but I think that
your argument in both cases, the way I read it, could be understood to be that the prosecutor was asking the jury to draw impermissible inferences about the defendant's state of mind from the way that he responded to the officer on the evening in question. So that when he said, you know, I'm driving from the Portuguese club to my home, it's not a fair argument to ask the jury to infer that he knew he had been driving under the influence. Or
and there was no breathalyzer. Again, it's up to this officer who said he had a moderate smell of alcohol and his eyes were glassy. And he just made that determination. And I know we allow officers to make that determination, but I also know that, you know, we're in a climate where officers are making a lot of determinations that are very significant, and this is not insignificant. And there's a choice to not use a breathalyzer. And I know this is not part of my argument. I understand it's not in my brief, but we're looking at the totality of this case. One of the aspects of an argument under a substantial risk of miscarriage of justice is we have to look at the case in total. And
right, but doesn't that also include the defense of the case, the theory of the defense? Because here, you know, as I said earlier, the defense is the officer had the wrong car. There's no way to know that this was the car the officer saw. The defense was not, you know, the defendant was not intoxicated, or there was no other defense. The defense was only misidentification in essence. So in that context, how is it that these statements rise to the level of a substantial risk of a miscarriage of justice?
Well, I rest on the argument of my brief that this statement made by the prosecution is an overreach and places on the defendant a burden to show that they have to prove, that they would have to prove, the whole notion that the defendant would have to prove that he was not intoxicated is very difficult in a case like this. I just don't see that as being, I see what's happened here as almost a shifting of the burden onto the defendant of having to prove their lack of guilt.
When you talk about substantial risk and the totality of the circumstances in the case and the need to examine the whole record, how should we consider the fact that on cross-examination of the officer, this is at page 69 to 70 of the transcript, the officer says, well, I asked him where he was coming from, and he said the Portuguese club, and he made no denial of driving at all. That was not objected to, hasn't been briefed. So
Right.
even if the prosecutor had, I mean, wasn't there a solid basis for the prosecutor to say there was no denial, he didn't protest?
He could say, what the prosecutor could permissibly say would be, and you may remember on cross-examination, the officer said he didn't deny it. That's fine to tell the jury, remember this testimony. However, it is a bridge too far to say, and therefore, I say that this testimony means the following.
Well, can't the prosecutor argue that a reasonable inference from the failure to deny it is consciousness of guilt, or
if he knew he was driving and he had too much to drink, and he knew that, I think is a lot to infer from his not denying.
well, that seems like a different argument than an impermissible comment on silence. That seems to be whether the argument was supported by the evidence.
I understand. I have no response, Your Honor. Unless there are any other questions, I would then rest on my brief. Thank you.
Thank you very much, counsel. Very good argument. I think we understand your argument. We will hear now from Mr. I'll mispronounce this as well, probably Bowden.
That is correct, Your Honor. Good morning, Your Honors. Nathaniel Bodwin for the Commonwealth. I would ask Your Honors to affirm the defendant's conviction in this matter. I believe the prosecutor's closing argument was a fair reply to the defense closing argument. I think implicit in what the prosecutor said was, when you have this, in this situation, you had a very cooperative defendant, very forthcoming in answering the officer's questions, providing documents that he had to the officer, that in these circumstances, it would have been natural for him to have mentioned that he was not the operator of the car, particularly when the officer testified that he asked Mr. Guamandui among the questions, there were two. One, when you took that right turn on Oliver Street, were you evading me? He said no. I think it would have been natural for the defendant to have said, not only was I not evading you, but I wasn't driving the car. Similar in terms of the question about where he had been coming from, the Portuguese club.
But what about the piece of it that the jury asked the prosecutor asked the jury to conclude, which was that they could infer consciousness of guilt regarding intoxication from the defendant's statements. That piece, to be frank, I don't understand how that argument can be made from what the defendant's statements were.
Referring to the prosecutor's statement that he knew he had too much to drink. So there was testimony that the defendant told the officer that he had drank 2 beers earlier that day. But there was testimony, there was evidence that he drank alcohol, in addition to the other factors that he was unsteady on his feet, that he had slurred speech, that he had glassy and bloodshot eyes.
Oh, I'm not talking about the sufficiency of the evidence of intoxication. I'm talking about the argument that the prosecutor made, inviting the jury to conclude something about the defendant's state of mind about his intoxication. I don't see how that inference can be drawn from the defendant's statements to the arresting officer.
I don't think it was improper for the prosecutor to say that. I think, again, he was sort of providing a roadmap, trying to say, when you look at all this evidence together, that you have a cooperative defendant who is very forthcoming, who...
I don't understand that. I've seen lots of arguments that non-cooperative defendants are demonstrating consciousness of guilt. This is the first time I've seen one that cooperating defendants are showing consciousness of guilt. And if both cooperating and non-cooperating defendants are both showing consciousness of guilt, it seems like maybe we have a problem.
And what I would add too is that, as Justice Rubin, you pointed out, this was not something that was one of the claims made by the defendant, so I did not have the opportunity to look at this, specific issue, whether this had come up in prior cases about this type of phrasing in a case with these circumstances. So.
I have a couple of questions that haven't necessarily been briefed, but I'm still interested in. When we have a charge of OUI, second offense or subsequent offense, the trial is usually bifurcated so that the jury in the first portion doesn't hear that it's a subsequent offense charge. They just determine whether the defendant was driving under the influence. And then if they come back with a guilty verdict, then there's a separate trial, whether before the same jury or a judge, about whether indeed the Commonwealth can prove that this was a second offense. So the jury, in hearing about the first OUI, doesn't hear about the charge that there were earlier ones, because that would be too prejudicial. So why is it in a case like this one, where the charge is OUI while under license suspension for OUI, the jury gets to hear all about the prior suspension for OUI? That seems to be just as prejudicial as in the subsequent offense case.
So, Your Honor, there was discussion during the trial with the judge, probably at sidebar, that there was had the defendant been found guilty of OUI, there would have been a bifurcated trial. And obviously, for whatever reason, he was found not guilty of that. So it wasn't necessary to have a bifurcated trial because he was not found guilty of OUI second offense. And in terms of trying a case where it's the situation here, OUI with a suspended license for OUI, I'm not aware that that aspect has to be bifurcated. I'm
asking whether that makes any sense to you. I mean, it seems like built-in propensity evidence.
Well, at the same time, in order to find a defendant guilty of that offense, there has to be some evidence that a license was suspended. So I don't know how a jury could come.
Not just that a license was suspended, but a license was suspended because of an OUI conviction, which I think is Justice Sachs's point, that it embeds the same evidence that we have in a related context determined as too prejudicial to introduce.
And I guess all I would say is I understand your point. You're asking my opinion of whether there should be bifurcated trials in this matter. I don't know enough about the issue to make a suggestion on that, but
yeah.
If it's an element of the offense, what are you going to do? I mean, you could stipulate, but the jury's still going to hear about the element of the offense.
May I ask you a different question? The defendant was acquitted of the OUI, but convicted of the OUI, operating while under the influence after the suspension for an OUI. How can I can't wrap my head around that.
Honestly, Your Honor, I think this is you may come across more trials than I do, and sometimes juries do things that maybe don't make sense from an outside party. And certainly when I first got this brief, that was the first, why did this happen this way? And of course, there was clearly, well, in my view, there was sufficient evidence to have convicted the defendant for OUI, just as I believe there was sufficient evidence to convict him for OUI on a suspended license.
Is one a lesser included offense of the other? Can you be convicted of both?
I mean, I believe you can. I believe I've had other cases where this comes up.
What's the additional element in OUI that isn't in OUI after suspension for OUI?
I don't have the statute in front of me, but no, I cannot think of a different element in OUI compared to.
Which is punished more harshly.
Oh, it is punished. Yes, there's a mandatory minimum. I believe it's a mandatory minimum of 2 months up to a year for the OUI on a suspended license for OUI. So there is an enhanced sentence.
I know that we don't consider factual inconsistencies between verdicts a ground for negating a guilty verdict. But does this cross over into the territory of legal inconsistency? It's not, I don't see how it's possible to be guilty of OUI while under license suspension while being not guilty of OUI for the exact same conduct.
I don't think the guilty verdict was legally insufficient. As I said,
Not
before,
insufficient, but legally inconsistent.
Inconsistent.
Yeah.
Like I said earlier, Your Honor, I can't explain why this happened the way it did. And I've certainly come across other cases where juries do things where I'm not too sure why they did that or why they came to those conclusions.
We usually say they can reach a compromise, they can do whatever they want. It's a very odd case, though.
Yeah, and we without going into how those deliberations occurred and what conversations happened, we won't know. We don't know why the jury came to this conclusion.
He was charged OUI subsequent offense, right?
Yes, second offense.
Subsequent offense, an element of the offense, or is it a sentencing enhancement?
I believe it's a sentencing enhancement.
All right.
But it needs to be found beyond a reasonable doubt.
Yeah.
By a jury.
Yes.
All right.
Well, at least the net effect was to avoid a duplicative conviction.
Possibly.
Perhaps.
It would be simpler if they convicted on the OUI and not on the OUI while under suspension. But as you say, we can't always understand how juries work.
Right. And if there are no further questions, Your Honor, I'd be glad to rest on my brief.
All right, very good. Seeing none, no questions. Thank you very much, both excellent arguments, interesting case, and the cases. I would just make counsel aware your cameras will be on throughout the proceeding. Your microphones may be as well, though they may not be, but it might be prudent to assume that your mic and camera are on at all times. Mm-hmm. The video of this is streamed live on the court's YouTube channel and will be available archived so that the public can see it later as well. So you should be aware of that. The rules for argument are the same here as they are in the courtroom, 15 minutes per side with no rebuttal. And our next case is number 19-1601, Commonwealth versus Bennett, and we will hear first from Mr. Lynn.
Thank you, Your Honor. Good morning. May it please the court, Paul Lynn for the Commonwealth. If all of the witnesses who now claim to have seen Tweet Blair shoot the victim or to have seen the defendant outside the club at the time of the shooting had cooperated with trial counsel, but trial counsel had decided to call only 6 of them, or had been limited by the judge to calling only 6 of them, on the grounds that the remainder of the witnesses would just be cumulative. And the defendant claimed 20 years later that he should have had the right to call all of the witnesses. The defendant would lose. But that is analogous to what happened here. When we started the proceedings on the defendant's 3rd motion for a new trial, we already had 6 witnesses that were either available to the defendant at trial or had been heard by Judge Spurlock. Sean Veal, who has been involved in all 3 of the defendant's motions for a new trial, or 4 if you count the last one, has always claimed that he saw Tweet Blair shoot the victim and then went outside, found the defendant, and talked to him about the case. Kendrick Clark, who was available to the defense at trial, said he was outside with the defendant at the time of the shooting. And then at the second motion, the hearing on the second motion for a new trial.
Mr. Lynn, I think what you're getting at is that an argument that all of the evidence presented on this motion was cumulative of evidence that either was available at trial or was available on a prior motion for a new trial.
That is correct.
You say in your brief that new evidence that would have been cumulative of previously known evidence carries less weight than new evidence different in kind. So I understand you to be acknowledging that cumulative evidence, that is evidence saying the same thing but from different or more witnesses, is not per se out of bounds on a motion for a new trial. It's just that it's got to be more or stronger in order to justify a new trial. Is that a fair characterization?
If I understand what you're asking, the Commonwealth's position, I mean, its initial position, its primary position is that if it's just new witnesses, it's not newly discovered evidence, period.
Well, what case says that?
Well, all the cases talk about newly discovered evidence. None of the cases talk about newly discovered witnesses.
Yes, but is there any case that says having a second witness who says the same thing as a witness who testified at trial is not newly discovered evidence, versus what I understand the cases to say, which is that second witness would be cumulative and it's entitled to less weight than if it was something really new?
There's no case that I know of that explicitly says that newly discovered witnesses are not newly discovered evidence, but it's the plain meaning of the word.
Are you challenging the defendant's reliance and the court below's reliance on Drayton as saying that an unwillingness to cooperate, which the judge found as a fact repeatedly here, that itself doesn't render the witness unavailable and therefore not newly discovered? Because it seems as though Drayton does say that you can have newly discovered evidence that's newly discovered because the person wouldn't have testified before.
Yes, that's absolutely correct. There's no question that a newly available witness, or excuse me, let me rephrase that. There's no question that a witness becomes newly available if they flatly refused to participate in the initial proceedings and now have come forward. But I think Drayton actually illustrates the point. In Drayton, this was new evidence. This was the first evidence. The affidavit from the dying witness was the only evidence that had ever come out that the key eyewitness in the Commonwealth's case couldn't possibly have seen what he claimed to have seen. So that's exactly what newly discovered evidence means. This was the first time anyone had heard any evidence like this.
Now, the judge said that this wasn't cumulative. I take it, I'd have to reread the judge's opinion. One piece of it that I remember clearly is the idea that at some point, quantitative difference is qualitative difference.
I think that's
at some point, yeah, sorry. So at some point, it's fine and good to say 2 people saw it, and that's okay. But when 10 people saw it, that becomes, qualitatively different, not exactly cumulative. And then he may also have said, and I'm not sure I remember this, but I feel like someone sitting near the bar or something, seeing it from a different angle, people at different points within the establishment is also not exactly cumulative. I think there was something about that. I might be wrong though. That I may be making that up.
I don't remember anything about the latter point, but certainly that was the gist of the judge's opinion is now that there's an avalanche of new witnesses, which, as you put it, is he ruled to be a qualitative difference as opposed to just a quantitative difference. But the Commonwealth's position is it's certainly an interesting question if you're going from 1 to 2 or 2 to 3, excuse me. But here you're going from 6 previous witnesses at the end of the second motion for new trial to 11, not including Jamal Douglas, who.
But we're not really testing this decision against the previous motion for new trial. The judges, you would if you were considering waiver or something like that. But we're testing the judge's decision against the trial, and there weren't 6 witnesses, right?
There were not. There were only 2 witnesses who testified.
2 witnesses, and now we have 2 witnesses, one of whom subsequently recanted, and then this they call it avalanche, but let's just call it large number of people coming up with information favorable to the defendant, and that the judge found was not the product of the defendant's efforts to procure that testimony, right? To get conforming testimony. The judge also found that there was no evidence that these witnesses had coordinated their testimony. And setting aside the question of whether this is new or cumulative, don't we have to deal with the ultimate question, which is the judge's determination that justice may not have been done in the original trial? And that is not, I think, coterminous with the question of whether the evidence is new or cumulative. That may certainly be a factor, but I don't think that's dispositive of that question. Do you agree with that?
Well, Your Honor, there's a lot of information that you put into that question.
Yep.
So I will try to break it down. The first point is that, yes, a judge rightly has the authority under Brescia and Drayton to consider simply the interest of justice, as the judge should. That's what we all should be working toward.
Right.
But as this court has emphasized in cases such as Francis and Kalanovic, which I cite in my brief, I also found while I was doing research for this, Commonwealth versus Lopez, which I believe Justice Rubin was on the panel, 96 Mass Appeals Court 34, 2019. It's essentially cumulative of Francis, which says the judge does not have unbridled discretion simply to say, I don't think justice was done in this case.
Right, but so I agree with all of those things. And we have a judge here who concluded that justice may not have been done. I take it that we review that for abuse of discretion?
Well, also for clear error. And the Commonwealth's primary position is this was clear error because it wasn't newly discovered evidence.
Okay, but
what he
even
turns
if
to,
the judge erred in finding that it was new evidence, how does that completely blow up the ultimate determination that justice may not have been done? What if it was all cumulative? It was just, there was one witness at trial who said this, and now it doesn't matter that there are 157 who've come forward unrelatedly to confirm it. It is very hard for me to understand why the sheer number is not to be considered by the judge.
It certainly is a relevant factor. The judge could consider it.
So once the judge can consider it, what's left of the argument that, oh, this has to be reversed because all these witnesses offered cumulative evidence?
What's left is that if this decision is allowed to stand, it's an invitation for people to come forward decades later to help a friend out, to help a fellow.
But is the problem here that I think we're all surprised by the outcome here because we see so many cases that are like this that come out the opposite way. And maybe because, although we didn't hear them, we have grown accustomed to presuming that witnesses like these are not credible. We've got this Douglas fellow right in the mix here, right? Which, it's like the 13th chime of a clock, right? It's like, like there's something wrong with all of this. Although, of course, the judge is very thorough in parsing each witness, including Douglas. But we can't do anything about the credibility judgments. I mean, the invitation to come forward with fake witnesses has already been issued, and people do it all day long. Usually, the judge says, "Yeah, okay, thanks for coming in," right? But in this case, the judge, and I can't second guess the judge. I wasn't there, right? Didn't think that's what was going on, or concluded as a fact that it isn't. Isn't that the real, sort of the nub of the problem here?
I think the underlying premise of cumulative evidence is not that the witnesses are lying. If a judge says, okay, you've called 5 witnesses, I'm not going to let you call any more. The reason the judge is not letting the defendant call any more witnesses is not because he thinks these witnesses are going to come in and perjure themselves, but just that the jury has heard enough to make its decision.
Yeah, but don't you think, well, all right, in a case like this, a murder case, if the defendant said, I want everyone in the club to come in who saw the other guy shoot the person and testify. I'm not taking any risks. I want the jury to hear that there were 10 in the original trial. If a judge had excluded some of those, wouldn't we call that an abuse of discretion?
No, absolutely not. If the judge had excluded some of those witnesses.
Case,
what?
In eyewitnesses in a murder case who say it was someone else? I don't know. I mean, I'm not a trial judge, but I think I'd let them all testify.
I think, just imagine the situation where you have, perhaps 40 witnesses.
Well, why is the person being prosecuted then, right? But if they were, I think that it's pretty tough to say, oh, people say they saw someone else do it and we're not going to let them, the jury hear them. I'm right. That's a tough one. I think.
But I mean, that case didn't happen.
No.
So I'm a little bit puzzled as to why that's a touchstone for what we need to look at here. If there had been 40 witnesses and the judge limited it to 6 or whatever number, 5, and then we have a motion for new trial based on the fact that all the other people want to be heard, that would be a different situation. That's not what happened here.
No, there were only 2 witnesses at trial, but we've had proceedings for decades here, and it's the underlying ruling is that from Judge Spurlock is this was a fair trial. So now we have a judge 10 years later saying no, it wasn't, just because of these 5 extra people who didn't come forward earlier.
But the judge did make credibility determinations.
Oh yeah. Yes, absolutely.
And there are 2 ways to look at prejudice to the Commonwealth. One is you have to retry a case, but the second is that you leave someone in jail serving a life sentence about whom a judge, having assessed witnesses, has doubts about the underlying conviction. And it looks to me like this is the latter situation. And if we're to review that for abuse of discretion, or as you say, clear error, but I don't really hear you identifying the clear error, I'm puzzled as to how we're to do that, how we're to substitute what looks to me like substituting our judgment for the judge's judgment, So maybe you can help me with that.
Well, I think if you look at cases like Francis and Lopez, the judge makes a determination. Look, nothing went wrong here, but the defendant clearly, take Lopez, the defendant clearly didn't understand the immigration consequences, even though they were told to him, even though he just made a bad decision. I'm going to help him out here. And this court said, you can't do that. So the judge is bound by the law. The judge does have to adhere to the proper standards. It's not just a sense that it's obviously the judge has to consider whether justice was done, but it can't just be, I have concerns.
Your time has expired.
May I?
Oh yeah, sure, of course.
Yeah, one further question, Mr. Lin, on the defendant's final argument that if he's entitled to a new trial on the Rose Club shooting, then he gets a new trial on the Grove Hall shooting as well because of the same gun, same guy theory. Was that raised, in your view, to Judge Krupp?
No, he didn't even raise it in his motion to reconsider. I mean, excuse me, he being the defendant. The defendant didn't even raise it in his motion to reconsider. And as I argue in my reply brief, you still have the gun in the hands of a good friend of the defendant.
Well, aside from the merits of it, I'm really looking, because I didn't see Judge Krupp addressing it in his very careful decision. I'm wondering whether it was raised at all. So your position is that it was not.
Yeah, this is the only issue on which the difference between this being a motion to reconsider and being a new motion actually has some relevance, because the defendant did raise it in his third motion, but did not raise it in his so-called motion to reconsider, and that's why Justice Krupp didn't address it.
Okay, thank you very much. Really excellent argument. Thank you. Very helpful.
Thank you, Your Honors.
We will hear now from Ms. O'Brien.
Thank you, Your Honors. Jennifer O'Brien for the defendant on appeal. Your Honors, the defendant is asking, obviously, for you to affirm Judge Krupp's decision. Judge Krupp carefully considered his decision in this case. We had a 3 to 4 day evidentiary hearing on the case. There were a number of witnesses who testified. The decision is 42 pages long, and it took him 2 years to come up with this ruling. It wasn't something that was done quickly. He carefully considered everything he was supposed to consider in rendering his ruling. I would ask the court, with respect to the Commonwealth's allegation that fake witnesses or witnesses who didn't see something can come forward years later and say that they saw somebody else committed the shooting, I'd ask this court to consider what's more probable or likely, that there was a shooting in a nightclub with over 200 people there where only one person saw what happened, or is it more likely that more than one person saw it and they didn't want to come forward and testify? Now, at trial, the Commonwealth had one witness to the shooting in the nightclub that put the gun in the defendant's hands. There have been many witnesses, 14 witnesses since, who have come forward and supported that it wasn't the defendant who did the shooting, and that they were afraid of the snitches get stitches rule, which was back in when this case was tried. It was a problem in the Commonwealth and the cities of Boston, and it's still a Commonwealth today. The Commonwealth seems to want witnesses to come forward to help them solve crimes only when these witnesses are helpful to them. I think the Commonwealth, I would hope, would want witnesses to come forward regardless of how long after the trial their testimony would have been relevant. They seem to say here. Yes.
Hold on. I don't know that that's exactly a fair argument. It certainly would have been helpful to the Commonwealth to prosecute the right person.
Absolutely.
And so in that sense, they want the witnesses to come forward at a time when it helps them in the administration of justice by, if it is as you contend, that there was another person who was the shooter, by bringing that information forward when it would have made a difference.
Yes, obviously.
Prosecuting the correct person.
Yes.
So I don't think it's really fair to say, I don't think your argument about the Commonwealth's interest is entirely fair.
Well, now they have come forward, though, Your Honor, and they've been called
after the putative shooter is immune from prosecution.
Absolutely. And at the hearing below, we presented evidence that Terrence Blair did have a violent record. We introduced his border probation record, which showed several firearms convictions, assault with a dangerous weapons. There was adequate testimony at the trial, even through the witnesses who testified, that they were afraid to tell. And that's something that I don't think could be taken lightly, because it's something that Judge Krupp carefully considered in his ruling. We had a witness who testified from a wheelchair. He had been shot 3 times, and the third time actually put him in a wheelchair. He testified at the hearing and still never said who put him in that wheelchair. So it was very powerful evidence of what the snitches get stitches code on the street is, and how it affects prosecuting people and bringing people to justice. And here, with the ineffective assistance of counsel and with the reluctance of witnesses to come forward, it created the perfect storm for a wrongful conviction here. I would state, with respect to the Commonwealth's argument about Judge Spurlock, and that this Judge Krupp, is just overturning Judge Spurlock's prior ruling. Judge Spurlock didn't have the benefit of Drayton, and I believe that was decided in 2018. So there were witnesses. The first witness And the first motion for new trial never testified. It was by affidavit. That was Veal. The defendant never got an evidentiary hearing. On the second motion for new trial, he did get an evidentiary hearing, and there were witnesses who testified not only that they saw Blair shooting, but they were afraid to come forward. And specifically the Chapman sisters, they were underage at the time. They were used to going to clubs, and they were afraid of getting in trouble for being, they didn't want to get involved in anyone's quote unquote murder business, but also they were afraid of getting in trouble for being in a club underage. Drayton came out after that, and it's clear that these witnesses would have been not cooperative. At the hearing, trial counsel testified that he knew about the Chapman sisters, but didn't bother to interview them because he heard that they were, quote, bitches from the DA. And he was asked if they were bitches to the DA, would that not lead you to believe that they might be helpful to you? And he admitted that that was the case. I think here the evidence is overwhelming that the defendant should be entitled to a new trial, even if the Commonwealth doesn't believe. I'm sorry.
I mean, I have to say, I don't know if the evidence is overwhelming. But I gather your argument amounts to that we need to defer to the credibility judgments of the judge and the judge's findings of fact. I mean, a lot of this rhetoric, whatever its merit, isn't sort of helpful to us. We're not de novo deciding this case. We have these standards, and I think fortunately for your client, they are differential standards to both the fact finding and this ultimate determination of whether justice may not have been done. But people coming forward 20 years later isn't an overwhelming case, probably ever.
Well, as you pointed out, this case is, I would argue, mostly based on the credibility of witnesses, which is left to the lower court's discretion. Here, the judge decided this on credibility and whether justice was done. When you have just one witness who comes forward, regardless of how long they wait to come forward, obviously that's something to consider in determining if they're credible. But if a lower court finds that their testimony is credible and they say that someone else committed this crime, then that is enough to determine that justice was not done in this case and that the defendant should get a new trial. And that's what happened here. I think it's again, I'm not arguing the merits of it. The Commonwealth certainly can retry the case. I know it's going to be difficult because their star witness to the Rolls Club shooting has recanted and did recant even prior to trial, but that's their right to retry the defendant.
May I ask?
Yes.
It was obviously, I think, a critical part of Judge Krupp's decision that the evidence presented in connection with this latest motion was not cumulative. Is that, yes, you'd agree with that?
Yes.
And this is all part of his exercise of discretion, to which we owe deference. So if we were to conclude that he was wrong about whether it was cumulative, because in fact, everything that each of these witnesses before him on this motion said was available to the defendant, either at trial or on a prior motion, does that error infect the entire exercise of his discretion? Or can we say that he would have reached the same decision even if he had acknowledged that this was cumulative?
I'm looking for the case, but I know it is cited in Judge Krupp's decision that newly discovered evidence and whether it's cumulative does not prevent a judge from granting a motion for new trial based on whether justice was done. And here, even if it was cumulative, a judge is able to look at whether justice was done, whether there was a substantial risk of a miscarriage in this case. So I would argue, no, that wouldn't stop him from granting a new trial. The evidence was not cumulative, and of course, I can't find it in his opinion, but Justice Rubin asked Attorney Lynn, wasn't there something in his decision where he comments, Judge Krupp comments on where different positions are, ability to observe, and that is in his decision. I was trying to find it, but each witness, obviously, even if they're saying the same thing, they're in different spots during the nightclub. Where Anthony Jackson was in the front, there was someone by the music box, by the jukebox. So that isn't entirely cumulative if people are standing at different positions in the nightclub. And certainly, even if people are saying the same thing, if you have 14 people saying that someone did it or didn't do it, that certainly strengthens the either side's case if you only have one person say that something happened. If I can just, I don't want to run out of time before I go, I just want to go to the last argument, if I can, with respect to whether a new trial should be granted with respect to all charges. This was argued below. Obviously, we had the new witnesses with respect to the Rose Club shooting. We didn't have any new witnesses for the Grove Hall shooting, but trial counsel testified, and he was asked questions about the investigation with respect to both shootings, because it was our argument below that he was ineffective as a trial lawyer because he, and it's in my brief, but there were, one of the reasons was there were 100 witnesses, over 100 witnesses that were given to him in a list 10 days before trial. Many of the witnesses who were at Grove Hall were also at the Rose Club. And I believe Judge Krupp found that there wasn't a failure to investigate and failure to properly find these witnesses. So it was argued that the defendant should get a new trial on everything. If you look at the way the case was—
Yes, but the question is, was it argued that if he got a new trial on the club shooting, therefore, ipso facto, he gets a new trial on the Grove Hall shooting? And where specifically was that argued?
No, it wasn't argued specifically. It was argued as a whole that the defendant should get a new trial in both cases because, again, we had arguments of the ballistic evidence. We had ineffective assistance of counsel for failure to investigate.
But the judge,
yes.
I mean, I understand the argument because the jury that convicted him of the Grove Hall shooting heard that he was the shooter in a nightclub a few days later. And obviously that's something that if that's now in question, one might think, well, but they shouldn't have heard that. But the judge found that there was not a risk of a the justice may not have been done with respect to the Grove Hall shooting. Don't we have to defer to that conclusion if we have to defer to the conclusion justice may not have been done with respect to the nightclub shooting? I mean, the judge was thorough about this.
Yes, the judge was thorough with the ruling. The judge wasn't thorough about why this wouldn't apply across the board. And I agree. Obviously, I'm arguing it consistently, as is the Commonwealth, that yes, there's no abuse of discretion with respect to the Rose Club, but there is an abuse of discretion with not applying it all across the board to the Grove Hall shooting.
Let me ask you the question maybe a different way. If we were to disagree with your argument regarding ineffective assistance of counsel, how do we overturn the judge's conclusion with respect to the Grove Hall shootings?
I think you can look at whether justice was done.
But given the only other information that we've got before us are all these witnesses coming forward and talking about what happened in the nightclub, the second shooting. No one says anything whatsoever about the previous shooting.
No, but
there's nothing new. What would be the basis for allowing that motion?
Well, I don't know that there has to be anything new with respect to that. The fact that
there has to be something.
There does.
Something. And I heard you say it's the ineffective assistance of counsel. But if we were to disagree on the ineffective assistance of counsel, what else would there be?
I understand what you're saying, Your Honor, but I don't know that there has to be something new with respect to each charge. We're here, the Commonwealth chose to try both cases together for a reason. And the ballistics evidence, which we know is not appropriate today, but it actually helps us here where the testimony was that the bullets were like a snowflake. No two bullets are different, are alike. So that actually helped us in the appeals court when the defendant first appealed this. The appeals court specifically said that there was a link between the two crimes, and that link gave the Commonwealth the opportunity to join these cases. So I think it's hard to parse that out where you have cases that were specifically joined because one case informs the other, and the strength of one case makes the other part of the case strong and vice versa. So here, if this case is now found to have been not just as far as the conviction against the defendant, where they tried together and they're so closely linked, I don't know how you say he got a fair trial where that evidence was used towards the second charge against the defendant.
Okay, your time has expired. Are there further questions for counsel? No. Seeing none, thank you both. Very interesting case, very good arguments on both.
All right, we are live and recording.
Good morning. It is still morning. Welcome to the appeals court. We are sitting rather obviously by video conference rather than in person due to the ongoing pandemic. Counsel are reminded that this is live streaming and also the video and audio will be archived so the public can view them later as well. And just as a reminder, I would act at all times as though your camera and microphone are on, as they likely will be. The rules here are the same as in our courtroom. 15 minutes aside, no rebuttal. Our next case is number 19-1646, DD versus CD, and this is an impounded case. So I'll remind the attorneys not to use the names of the parties, referring to them by status or initials should be adequate. And we will hear first, I believe, from Ms. Tobin.
Good morning, Your Honors, and may it please the court. My name is Melissa Tobin, and I'm representing CD, the defendant appellant. This abuse prevention order was issued based on the theory that the defendant placed the plaintiff in fear of imminent serious bodily harm. At the two-party hearing, the plaintiff offered no evidence of physical abuse, attempted physical abuse, threats of physical abuse, or sexual assault. The plaintiff instead relied on the theory that the defendant's actions placed her in fear of physical harm. We're asking this court to find that the trial court committed an error of law by issuing the abuse prevention order against the defendant where there was insufficient evidence to prove objectively reasonable fear of imminent serious bodily harm as required pursuant to Chapter 209A. Now, in discussing why there was insufficient evidence to give rise to objectively reasonable fear, today I will be addressing the evidence that was presented to the trial court. So first, I will be discussing the defendant's attempt to speak with the plaintiff at her home. Then I'll be discussing the statement made by the defendant at the divorce proceeding, and then the vague testimony given about prior abuse and statements during the party's marriage. I would then
all of this evidence we take in the light most favorable to the plaintiff, correct?
That is correct, Your Honor. And after that, I would like to briefly discuss the cross appeal and the issues raised by the plaintiff in that appeal. So looking at the transcript in the light most favorable to the plaintiff, it may be true that she subjectively feared the defendant. However, the standard for determining whether the defendant's actions rose to the level of abuse under 209A is not subjective. We have a long body of case law that the trial court must make a determination that the plaintiff's fear was objectively reasonable. The trial court here does not make an explicit determination that there was a finding of objective reasonable fear. And even if the court credited all of the plaintiff's testimony in its entirety, the alleged conduct is insufficient to cause reasonable fear of imminent serious bodily harm.
All right, so the defendant comes to the plaintiff's house late at night with no explanation and no attempt to contact her beforehand after a period of no contact and a non-civil divorce context, and a context in which the party's daughter has just severed contact with the defendant because of his abusive behavior towards her. He has a history of, I'm going to call it abuse in a non-technical way, just abusive behavior towards the plaintiff. The situation is volatile in the sense that there's a divorce. He's made a comment drawing that specific link between divorce and harm to the plaintiff. He's told her she needs to be careful for herself or something like that. You better watch out, or whatever that the statement was.
You'll be sorry.
You'll be sorry. And he has a large number of guns. So in that light, and I may have missed some things, I don't know, but in that light, how is the plaintiff's fear of imminent physical bodily harm not objectively reasonable?
Sure. Thank you, Your Honor. Just one clarification. I do want to state that there was no evidence at the hearing that the defendant had a large number of guns. The plaintiff did state that the defendant did work in law enforcement, so did have access to a gun.
Right.
So taking all of these situations, we have him going to her house after not much contact. I will say that when he went to her house, there was no threats, there was no menacing gestures, nothing of the sort. He went to the house, tried to make contact. She shut off the lights. He took that as, okay, she doesn't want to talk to me. So we got in the car and he left.
You're not taking the evidence in the light most favorable to the plaintiff. In the light most favorable to the plaintiff, he came to the house, didn't knock on the front door, went through a gate to the back door, and either knocked or rang the bell. I mean, I in the light most favorable to the plaintiff, he had threatened her repeatedly with these statements that, while I understand if you weren't looking in the light most favorable to the plaintiff, you might say he was just telling her about this fascinating fact about when women get killed. But she testified that she understood them to mean to be threats. She said things like, then why did you constantly bring this up in front of me and my friends if you weren't threatening me? There's evidence that he said that if she filed papers against him, it would enrage him. He would treat it as a poke in the eye. I mean, I don't know. If you take it in the light most favorable to the plaintiff, I don't see how you can say the judge couldn't find it reasonable for her to be in fear for her physical safety, particularly with the threat, you'll be sorry, is the last thing he said to her. The last time they talked, he said, you'll be sorry. And now here he is.
Sure. So if we look at that statement, this statement happened at a divorce proceeding relating to property division. We learned about that through the both of their testimony. And the testimony was that at some point during a recess, the defendant stated to her that she'll be sorry. This is a very vague statement.
So take it in the light most favorable to the plaintiff.
In the light most favorable to the plaintiff.
In the light most favorable to the plaintiff, it's a threat of murder, I think. You'll be sorry. I'm going to kill you. You'll be sorry.
I would suggest that the conclusion that the statement of you'll be sorry more closely approximates the statements made in Keene versus Ganji, where the defendant was saying to the plaintiff that he could have somebody taken care of, that he'd been in the plaintiff's home without her permission or knowledge. Those kind of statements in Keene versus Ganji were found not to be enough to prove reasonable fear of serious imminent bodily harm.
Well, they might not be enough by themselves. And as you point out in your brief, the plaintiff originally said that she wasn't scared at the time that the you'll be sorry comment was made. But in light of the subsequent events, particularly the incident of July 7th, can't the judge take that prior comment into account in evaluating whether the plaintiff's fear is reasonable?
Yes, and the judge should take that into account in making that determination. But again, if we look at King versus Ganji, we have this relationship where these statements are being made to the plaintiff, these vague statements that sure, a defendant saying to the plaintiff, I can have somebody taken care of. I think that that rises to a level that more so suggests a threat of murder or a threat of physical harm than the vague statement of you'll be sorry. We don't know what that means in that context.
No, we don't exactly. We have some context, though. I'd like to ask you about I should also note, of course, this is obvious to everyone, the clock has disappeared. I assume the clerk's office is aware of that.
I somehow I became the host of the meeting,
Yeah.
and I just made the clerk's office the co-host.
Okay, well, I don't know what the issue is, but I'd like, we're going to keep going with the argument. I don't recall what time it started. The clock went off at 11:11 a.m. and I can't imagine you were much more than 4 or 5 minutes into the argument by then. But let's keep going, and hopefully they'll get us a good clock. And if not, we'll stop at some point. Can you talk about the cross appeal a little bit? I'm trying to understand. A judge comes in to a hearing that is not about extension. So she hasn't read anything about whether an order should be extended or not. And she announces, I will not extend this unless there's a violation. How is that due process?
Sure. So the May 7th hearing, there was some confusion at that point with the trial court judge. They believed that that was the extension hearing. It was actually the motion to vacate hearing. We do have statements made by the judge that she was not going to issue the order unless there had been subsequent acts. And I think that it is understood that judges do have broad discretion to determine whether or not there is a continuing need for an order. And that's
Sure, but don't they have to hear the evidence and the arguments? Don't they have to be neutral before they hear the evidence and the arguments?
Yes, they do. And I'm suggesting not that a judge should be predetermining an issue in that way, but rather that we don't have enough information about what the judge was really thinking at that time. And part of the reason why we don't have any of that information is because trial counsel failed to object on 2 occasions after those statements were made. There was the same attorney that represented the plaintiff at the May 7th hearing and the July 9th hearing, heard these statements both times and never objected, never inquired about it, never requested the judge recuse themselves.
So you think this argument is waived?
I would argue that it is waived, yes, because trial counsel had 2 opportunities to object and didn't. And I think that likely that was because this is a judge they wanted to keep on the bench. This was the judge that had issued the original order, clearly was upset with the defendant for going to the plaintiff's house, denied the motion to vacate, and they wanted to keep that same judge at that hearing.
Well, I don't know if that's fair. At the hearing on the motion for the defendant's motion for reconsideration, plaintiff's counsel raised the concern when the judge said, you know, I'm not going to extend it. She said, well, I would be able to come back if I had new evidence, right? And then the judge said, no, I'm telling you right now, I'm not going to extend it.
Correct.
So whether or not that's an objection, technically an objection to that, it does seem that the counsel raised an objection and the judge overruled it. So why isn't that enough?
So I would suggest that it's not enough because counsel decided to go forward and was actually given the opportunity to present evidence and be heard on the matter.
Not to present evidence, just to argue. The brief below asked, as I understand it, for an evidentiary hearing, but none was held. And I can't see how, based on the argument at the actual extension hearing, it seems as though the proffer was evidence of exactly what the abuse was in the household that it seems to me might have had, I don't know what the evidence would be, bearing on the question, is she still in reasonable fear? And I just don't see how you can exclude that and say a priori before you've heard it, no, that whole category of evidence couldn't change my mind, because the only thing that would change my mind is a violation?
Sure. So I do want to just state that these are 209A orders, 250AD orders. They do tend to be very informal proceedings in the district court. It tends to be a dialogue, somewhat of a conversation between all of the parties. And so the judge did make these statements about not feeling like there was grounds to issue the order without something else being presented. But trial counsel did tell the judge that she wanted to be heard on the matter. And then the judge did allow her to be heard on the matter. The trial counsel offered a decently extensive argument, and there was back and forth between her and the court, and never at any point did she request to put the plaintiff on the stand to testify. There was never any refusal to let them put on evidence. The trial counsel told the trial court judge that she wanted to give reasons why the order should be extended, and then did so. And the trial court did hear her on those issues and considered all of those issues. We can see with the back and forth that the trial court is considering that argument in that moment on extension. And these statements that were made by the judge about not thinking that there were going to be grounds to extend without something else happening, I would say that judges do have broad discretion. However, judges should not give the appearance of predetermination or bias or anything along those lines. So the judge probably shouldn't have said that. But in this case, I think that the judge did take the time to consider all of the evidence presented by the plaintiff and still reach the conclusion after argument that this was insufficient to establish a continuing need.
Well, I don't know. I'm looking at that hearing and it's all of 4 pages long.
Mhm.
So I don't really see any evidentiary component to it. Can you point to me where there's an evidentiary component?
There is absolutely no evidentiary component to this. However, if you look at the motion for reconstruction where trial counsel submitted their affidavit, there was a piece of the transcript that was cut off. We can see that trial counsel does ask the judge to give her argument and to present her case about continuing need, but then decides not to call the plaintiff to testify. She never called the plaintiff to testify. The judge never actually made a denial of that request to have the plaintiff testify. So we don't know what would have happened in that situation because the judge was never given an opportunity to make that denial. And the judge was never given an opportunity in the moment to clarify what she meant when she made these statements because trial counsel never brought up that issue at the time. So I would argue that, predetermination, there's insufficient evidence here to suggest that the case was truly predetermined and that the plaintiff didn't have an opportunity to be heard, where we don't see the judge actually denying trial counsel's request to put on any evidence or trial counsel's request to call the plaintiff to testify. That never happened. I would like to shift back at this point to the issue of reasonable fear. And I would like the court again to consider the facts in Keene versus Ganji in looking at the case we have here. In Keene versus Ganji, we have statements being made that could be alluding to a threat. Similarly, in this case, we have vague statements made by the defendant that may be alluding to some type of threat. We don't know of what. And there's no history of past violence in this relationship.
In Keene versus Ganji, had the defendant come to the plaintiff's house unannounced at night and gone to a side door?
The defendant in that case did not. Instead, the defendant had the plaintiff install a clock that had a camera in it, violating our privacy. I think that the issue with the defendant going to the side door, to the slider of the plaintiff's home is an issue of privacy. I think we can concede that he shouldn't have done that. He should have stayed at the front door.
Well, but it's also physical presence. Yes, a camera invades privacy, and so does looking in a slider, but looking in the side slider also brings him into close proximity with her, and she said the door was unlocked. She knew he carried a gun.
Sure, but there was no evidence of him making any threats while he was there. He'd never been to this house before. Surely when people go to homes, there could be different entrances, different points to knock or ring a doorbell. He tried one doorbell, it didn't work.
Only if you believe him. He tried a doorbell if you believe him, but in the light most favorable to the plaintiff, he didn't try a doorbell. He just went around back.
Sure, so if he did not try the doorbell, if he went around back, then we have a defendant walking into a backyard for a matter of maybe a minute and then leaving. That's all we have there. We have him going into a backyard.
I think sitting in his car in the driveway, actually, not leaving, in the light most favorable to the plaintiff, right?
And again, I understand that the plaintiff did testify that she saw the defendant remain there for some unknown period of time. We don't know if this was 10 seconds. We don't know if this was 10 minutes. We know that she conceded that at the moment, she didn't know if she really needed to call the police.
But then she did call the police, right? And they showed up and he was still there?
He was not still there.
Okay.
Yeah. So we don't know where the timeline is there because, again, the plaintiff offers no specific details really about any of these issues. When we talk about the plaintiff's testimony about statements made during the marriage about domestic violence, we have no context, we have no timeline. The testimony is that the parties were married for 25 years and that they were separated 3 years prior to him knocking on her door. So we have some time between 3 and 25 years ago, the defendant making these types of statements. We don't know the context. We don't have any information about, was he being hostile? Was he yelling? Was he making...
Your time has expired. I think we understand your argument. Thank you very much. Excellent argument. Very helpful to us. We will hear now from Attorney Stedman.
Thank you, Your Honor.
Thank you, Your Honors. Angela Stedman on behalf of the plaintiff. Turning first to the appropriateness of the judge's decision issuing the abuse prevention order in July of 2018. I think what defense counsel wants to do is say that all this is a ex-husband showing up at an ex-wife's door. And if that's all it was, she would have an argument to make. But everything has to be put in context. And it's the context here that made his appearance at her house so terrifying to her. And I suggest that context makes her fear and terror reasonable. He shows up at her doorstep, not during daylight hours. He shows up after dark, 9 p.m. He doesn't go to the front door. He goes to the back door. He has a history of always carrying a gun. My client is small, frail, fractured vertebrae and walks with fractured vertebrae and walks with a cane. We have the timing of when he showed up at her doorstep. We know it's a couple of months after a contempt hearing during which the defendant approached my client from behind and whispered so she could feel his breath on her neck, "You'll be sorry." Again, with respect to timing, we know it's shortly after the party's daughter had broken off contact with the husband, with the defendant, because of his abusiveness. And my client knew that as something that would make him very angry. And then we have the history of the marriage, during which my client testified that the defendant had made menacing comments to her throughout the marriage, had told her that he would murder her if she tried to leave, and that he was abusive of her during the marriage. If you take, and I may have been forgetting some of the other factors cited in my brief, but the point being, if you take all of these factors together, the defendant's appearance at my client's house on July 7th was something that put her in fear, and the judge believed that she was very fearful. The judge rejected the defendant's testimony that he had a legitimate reason to be there to discuss his estrangement with his daughter. The judge rejected his testimony, found it unbelievable. My client knew he had no reason to be there. All these factors taken together makes her fear reasonable. And the judge's findings in that regard are completely supported by the record. And for that reason, I suggest the issuance of the restraining order was appropriate. Turning next to the argument that there was waiver of my client's.
Before you turn to that,
Sure.
do you agree with your sister's argument that the judge needs to make an explicit finding of fear of objectively reasonable fear of imminent physical harm? Because I don't think the judge did make that, to the extent that we look to her statements on the record as her findings, she doesn't make an explicit finding to that effect.
I don't believe that legal proposition is true. I don't believe the case cited stands for that proposition. And I would add that the judge at one of the later hearings, I can't recall if it's the May hearing or the July hearing the following year, does state on the record that she made the finding that the fear was reasonable. But putting that aside, I believe that for purposes of appeal, what needs to happen is to look at the record to see if a finding of reasonableness is supported by the record. In this case, it certainly is. And that a judge at a abuse prevention order does not need to specifically articulate each and every finding that she made. I found no case that would stand for that proposition. Okay, so turning next to this claimed waiver, we know, looking at the transcript from the May hearing, that the judge indicated that she would not be extending the abuse prevention order unless there was another incident. She stated that on the record, and she more than once, and she further stated on the record that she was going to make a note to that effect in the file. We know that that's the wrong standard to apply, because in Vitone versus Claremont, we know that there are a variety of factors that a judge is supposed to consider, and that another incident is but one factor. We also know from the statute that the statute itself that a lack of additional incidents in and of itself is not a sufficient reason to deny an extension. So we know, as of the May hearing, the legal standard she's applying is wrong. We know that the judge is not appropriately following the statute, because the statute specifically provides that the decision about whether or not to extend needs to be made if the plaintiff appears on the date that the restraining order is scheduled to expire. But we see that in the record. She makes that comment in passing. I don't believe that an attorney is obligated to specifically indicate to a judge each and everything he or she takes issue with.
No, but shouldn't the attorney have at least made an offer of proof?
I don't think she needed to make an offer of proof at the time of the May hearing.
No, the May hearing is the hearing on the motion, the defendant's motion for reconsideration, or
That is correct.
What about at the hearing on you're seeking an extension, your client seeking an extension of why is it that you don't need to make at least an offer of proof to the judge?
I believe she does make an offer of proof after the judge twice specified that on the date of the next hearing, the July hearing, twice specified that she would not be extending the order because there were no additional incidents. My client's trial counsel went on and articulated factors which she believed would support the extension of the abuse prevention order. She did not call the witness. She did not call the witness because she was told by the judge had already decided the case. What she was able to do was make a verbal offer proof to preserve the record on appeal to the extent she could in light of the judge's indicating that the matter had already been decided, and we're saying inappropriately decided, without due process and without compliance with the statute. I don't know if anyone has any other questions. I believe those were the points I wanted to make, and everything else I would rely on my brief.
Excellent. Seeing no further questions. Very good argument on both sides. An unfortunate case, certainly. And
We are recording and streaming.
good morning. Welcome to the appeals court. We are sitting by.
Recording and streaming.
Morning. Welcome to the appeals court. We are sitting by. Someone has their
Your Honors, does someone have the YouTube page up and open?
Maybe that's Attorney Shapiro.
If you could just please turn it off so we don't hear the background noise. Thank you.
Sure what you mean yet.
Do either of you have the YouTube page open, because we're getting some echo?
We're working on that now, Your Honor.
We are sitting by video conference rather than in the courtroom in light of the ongoing pandemic. Counsel are advised that their cameras and microphones may remain on throughout the entire proceeding. The proceedings are streamed live on YouTube and archived so that the video may be watched by members of the public at a later time. We follow the ordinary rules of our courtroom here on video conference, which is to say 15 minutes aside with no rebuttal. The next case we will hear is number 19-1378, Haddad v. Haddad. And we will hear first, I believe, from Attorney Shapiro.
Thank you very much, Your Honor. May it please the court. I'm Attorney Jordan Shapiro, and I'm the successor counsel to the trial attorney, Stephen Kramer. By the way, this is the first time I've stepped into a case after a trial, and I now realize the complexities of doing that. But Mr. Kramer has been very helpful, telling me what he was thinking about as he was making decisions. And so I want to cite to you right away the Barnard case that is cited at page 33 of my brief, in which I conclude that the appeals court is in the same position as the trial judge and can consider the decision by the trial judge but not required to defer to it, unlike usual, as cited by Attorney Woods, abuses of discretion and erroneous when dealing with facts. So you may decide whether you would have done the same thing that the judge did. And so Attorney Kramer wanted me to be sure to emphasize to you that he felt that he was ambushed twice on this particular matter. And the first time is when there was a failure to disclose necessary information until 2 weeks before the trial. And at page 25 of Attorney Woods's brief, he says the fact that the appellees intended to use a medical expert trial was clear based on the joint pretrial memo dated July 3rd, 2018. That's the volume 1, the record appendix 142.
But at
Mr.
the,
Shapiro, I have a couple questions for you about the pretrial conference that was held 2 weeks before the trial. This was when the plaintiff's so-called final pretrial conference memo was produced to you with the expert disclosure that's at issue here. It appears also that there was a flash drive of information. I don't know exactly what was on that, but these scans were apparently on it. I've read the transcript for that hearing, and a couple things jump out to me. The first is, and I just want to make sure that we're on the same page. So I want to make sure that factually I've got it straight. The first is trial counsel, your predecessor, did not deny that there was that he was given a flash drive. He did not deny that he had been provided the 2010 scan or the scans. The judge asked whether he wanted the topic of this late disclosure in the 30B for the 30B expert disclosure came up, was extensively discussed. The other side agreed that you would be entitled to discovery, including deposing that person. I take it you didn't take up that opportunity, and the judge offered to continue the trial for your client to deal with the element of surprise. Do I have all of that correct?
Yes, but the conclusions that you arrive at from
I'm not
having
arriving at a conclusion yet. I'm just asking whether those facts are correct. If so, and because there are parts of your argument that I get a little bit confused by. So I want to talk about the ambush point, right? How can you be quote unquote ambushed when you're given the opportunity to dissipate whatever surprise, and undoubtedly this came as some surprise, I guess, to receive this disclosure in this new pretrial conference report. But when you're given the opportunity to avoid or mitigate that surprise, and then you don't want any of those options. You just don't explore them, you don't take advantage of them. How can you then on appeal argue that there was ambush?
And the answer to that question is that the huge documents that have been produced for counsel, thousands of pages in the box, and then his giving us a flash drive with, we don't really know what was on there. There is nothing that he said that he wanted to mark as an exhibit to be used at the trial that would be relevant to our responding and having us use that opportunity to look and depose the doctor further, because again,
Can I follow up on Justice Wolahojan's question, because I see exactly what you're saying, which is it's all fine and good to tell us Dr. Shervin is going to show up. It's another matter to say, oh, and he's going to opine about this 2010 and 2011 scan that he didn't do, that we either are or not, we're not particularly aware of it. I get that. I guess I have two questions about it, though. First of all, where does the obligation to point to, I assume the flash drive was turned over in discovery, although I have no idea what you asked for, and I have no idea how it was indicated it was responsive, and I don't know whose burden it is to show us that. But assuming it was turned over in discovery on a flash drive, do they have to tell you what's in the discovery they're going to use? Or do you have to go through all the discovery and see what might be relevant?
the duty is for them to tell us what parts of the thousands of pages on the drive is going to be used as an exhibit during the trial.
And where does that obligation is the 30B obligation?
It's part of the, it's part of the preparation for trial. We were asked to mark exhibits to be used at the trial, and those
But weren't these marked?
Any in the pre-trial memo.
I'm sorry to interrupt you. Weren't these scans marked as contested? Weren't they put in the contested exhibit binder? Weren't they somehow identified as contested exhibits?
I don't believe so, Your Honor. But again, I'm not 100% sure.
Okay, if they were identified as contested exhibits, what more is required?
Then
there was a binder of agreed upon exhibits, and then there were contested exhibits.
If I thought that was in any way marked as an exhibit in the binder of exhibits, I would have probably not taken the position I've taken in this trial throughout. So I doubt that this word, let me say this, Your Honor, at the trial, Attorney Kramer was all over the judge and Mr. Woods in saying that the word scan had never come up at any time before the actual were used at the trial. So I believe your assumption is incorrect, that it was never disclosed before.
You know, I took a little bit of issue with that statement, frankly, because when I read the pretrial hearing conference transcript, the word scan, I think, did come up. But, you know, Justice Rubin's question, I think is I want to follow up on, which is that when documents and materials are produced in discovery, it has always been my understanding that the recipient has an obligation to look at them. I mean, you may choose not to, but at least good trial practice is to review what it is that the other side is giving to you in discovery. So unless you can say that the scans were not produced in discovery, it's hard for me to understand the element of surprise. And I've never, when I was in practice, I never had to point to anyone. Look, you need to really pay attention to this document. It's going to be important. The other side has to do its own work too.
Well, but again, don't forget that he has the duty to supplement his responses to discovery. And under Rule 26, he had the duty to produce all documents that he was asked. The rule question 12 of the production of documents, he asked, produce all documents that show you're suffering from dementia, and the response was none, and that was never supplemented. And the party is required to supplement, but he knows the response is no longer true. So he never supplemented interrogatories or production of documents. He came in with an unauthorized and unapproved pretrial memo that he came in on his own. It's not allowed. The pretrial memos, it says within the Rule 26, you're not allowed to add new documents after you have submitted the final pretrial memo. And here he comes in with a new one that again was a surprise and an ambush. And my client only had 2 weeks to prepare. And again, I do hear—
He had the option to have more time.
Well, I guess
which he declined. And there may have been reasons to decline that, but the judge gave the option.
Is there some reason you're not talking about Rule 30B, Counselor?
I am talking about 30B. I would like to talk about 30B a lot, actually. And so 30B is another rule that was violated because, again, he filed the court-authorized pretrial memo in July of 2018, and he did his own, where the rule says no party can reserve the right to make a later disclosure, and that's exactly what he did in violation of 30B. And so all of those things were part of the ambush.
That the part of 30B that says that if you're going to have an expert, you have to identify documents in the same way you would if you were answering an ordinary interrogatory about an expert. And now my question is this: what under that standard, the interrogatory standard, do you just have to announce who the person is, who the expert is, and say they'll rely on medical records? Or do you have to point to the specific records, scans, x-rays, whatever, that they will look at? And where will I look to find an articulation of that rule about interrogatories?
And that is, again, in Rule 30B. Must identify the subject matter, the substance of all facts, and opinions. And so in the document that was produced,
whoops, we were losing your audio.
In the document that was produced by the appellee, excuse me, at page 764 of volume 2, what we received was the doctor's report, and in the bottom of it, well, not the total bottom, but in the middle of the first page, there was no evidence of a dementing process or an encephalography during that hospitalization. And that was in the doctor's 213, the only thing he reports in his 213 response that was the doctor's evidence that we expected him to testify about, was that there was nothing that was evident in 2011. So why would we want to do any further discovery if that's all we're getting is information that in 2011, there was no defects in his memory or his mental capacity? And so that's why actually Attorney Kramer, when he was offered the right to have a further deposition, and the attorney didn't supplement further as required by 30B, and there was, again, no mention in this document of brain scans at all. Again, this document is the doctor's report at page 764, volume 2, that the doctor's report, that was what was provided to us as to what the substance of his testimony would be. And it certainly doesn't indicate anything about scans or relying upon scans, or that there was even a problem in 2011 that we should be concerned about.
Your time is getting short, so.
Oh, goodness. I want to hurry.
I would appreciate it if we could turn to the Daubert-Lanigan argument. And,
yes.
And you made no Daubert, or maybe I should say, where did you raise a Daubert-Lanigan challenge down below? Just give me a record site.
Oh, down below? No, I agree that the council did not raise that, but that does not start the judge from being a gatekeeper.
All right, but and then the second question I have is, I don't really understand your Daubert-Lanigan challenge. I take it you are not challenging Dr. Chervin's qualifications as a neurologist.
Correct.
You explicitly did not challenge that down below.
Absolutely.
You are not challenging his ability to interpret brain scans. Is that correct?
Correct.
And you're not challenging the methodology by which he is interpreting brain scans. Is that correct?
Correct.
All right. So if all of those, and so for example, the brain scan that was taken in conjunction with his own examination of the decedent, you don't have any Daubert-Lanigan concern about his ability to offer an opinion as to what that scan showed. Is that correct?
Incorrect.
About the scan that was taken in conjunction with his own examination of the decedent?
Yes, and the reason is that during the trial, he never testified that he had an opinion that based upon reasonable medical certainty accepted in the general professional opinion in that gathering of evidence, that it was with reasonable medical certainty that he had no testamentary capacity in 2011.
He never offered that opinion.
He did not offer that opinion.
He never offered that opinion. He never offered that opinion. So that is not subject to Daubert-Lanigan. He never offered an opinion about testamentary capacity at all.
And that was required.
And that was not my question. No, I don't know if that's required under Daubert-Lanigan. Daubert-Lanigan is a gatekeeping function with respect to an opinion that's actually offered. So here, the question I have for you is, the doctor offered testimony concerning his interpretation of the scan taken in conjunction with his own examination of the decedent. Do you recall that testimony?
Yeah, for sure.
Right.
And there was nothing.
Do you have any Dalbert Lanigan concern about the doctor's testimony with respect to what that scan showed?
Yes, with regard to the reliability of the doctor's opinion, that's only his own opinion, with regard to the reliability of that opinion based on reasonable medical certainty. And that's what it is all about, Your Honor. I think
his
we
own
didn't get
opinion,
that opinion.
the opinion that he, excuse me, the opinion he drew contemporaneously of the scan that was taken in conjunction with his own examination of the plaintiff.
Oh, I'm sorry. I didn't know you meant the 2013.
I've asked this now 3 times.
I'm sorry.
I've asked this now 3 times. His own examination of the plaintiff, there was a scan taken in conjunction with that. Do you have any Dalbert Lanigan concern about that?
Well, again, the reliability of his opinion is whether it's
what was the opinion he offered?
Well, he offered an opinion that the fellow was suffering from severe dementia.
Well, he offered an opinion about his interpretation from that scan.
Yes.
And what do you think is the Dalbert Lanigan failure there?
Whether other doctors in the community would have accepted that as reasonably acceptable language.
Interpretation of that scan?
Correct.
But that challenge was not raised below.
It wasn't raised below, but I think the judge has.
And so is that the same Dalbert Lanigan challenge you're raising to his interpretation of the 2010 scan?
Exactly.
The problem here is that he did not say that everyone else would have the same interpretation?
That is certainly, yes.
Is there any other component to your challenge?
Well, I think that, again, the lack of an opinion by the doctor is something that the judge should have excluded his whole testimony because he lacked the opinion as to with reasonable medical certainty that the fellow was incapable.
Doesn't that go more to the sufficiency of the evidence? The doctor did not offer an opinion about testamentary capacity. It seems to me that that's part, or it should be part of your argument that there was insufficient evidence for the judge to conclude that he lacked testamentary capacity. I don't see how an expert can be, a Dalbert Lanigan challenge can be offered against an opinion that the expert doesn't offer.
Oh, you offered
the expert did not offer an opinion on testamentary capacity. So how could he have fallen short of Dalbert Lanigan?
The court should have been looking for that and have required that as the gatekeeper.
That's a different argument.
That is a different, I agree. That is what we say is when we refer to the gatekeeper duties of the judge. But I just...
No, your time has expired. No.
I just want to talk about the attorney's fee.
Okay, well, we've got your brief before us. Thank you very much.
I did want to comment that the judge below did not authorize attorneys.
Okay, your time has expired. So, Attorney Giordano, we turn to you.
Yes, good afternoon, members of the panel. If it please the court, Catherine Giordano on behalf of the plaintiffs, Joseph and Alan Haddad. There really is just one main issue in this case. Did the trial judge abuse her discretion when she permitted Dr. Paul Shervin to testify and to use as part of what he did testify about the brain scans which had recently surfaced? So to unravel the answer to that abuse of discretion issue, we are going to have to unpack Rules 26 and Superior Court Rule 30B. But before we get to that, I just want to sort of provide a little roadmap here, sharing 3 important takeaways from the Beaupre case cited on page 32 of our brief, because it sort of gives us a nice little compartment to begin with. In that Beaupre case, this court said that when it comes to cases involving medical expert testimony, it isn't just a question of the regular deference given to the trial judge, but there's great deference given when it involves expert medical testimony. The other bullet point we can take from Beaupre is
in this
that
case, are you referring to the 30B argument? I don't think Beaupre had anything to do with 30B.
No, it did not, Your Honor, but it did have to do with discovery and how one proceeds with late admitted testimony.
All right, so let me just tell you, and I know we're all drawing on our own experience here, but there was not a single time that I produced an expert report or an expert disclosure that did not identify A, the expert's qualifications, B, the expert's opinion, and C, the documents upon which the expert was relying to reach that opinion. And I think A is probably satisfied here. I think B might be in terms of the 30B disclosure, but I don't see C anywhere. So would you please tell me where, before this trial began, you disclosed exactly which documents the doctor would be pointing to for his opinion?
Yes, I'm glad you asked that, Your Honor. What happened here was
I'm looking for a record site.
In terms of Rule 30B?
Just tell me the record sites of where, when I look through I looked, and I didn't see a disclosure. So I'm not looking for argument here, with all due respect, but for actual record sites, because that's what I need at this point.
Well, let's go back to the complaint, Your Honor. Paragraph 15 of the complaint.
That didn't attach it. I saw that. It did not attach that in any way to the expert's opinion.
Yes, Your Honor.
Where is it that I will find in the record that says Dr. Chervin will testify ABC, and that opinion, he's going to rely upon documents XYZ?
That would have been mentioned both in the July pretrial memo, which says that we anticipated selecting a medical expert who had the opportunity to review all of the records.
Right. So in other words, it doesn't say what I just asked. And then
doesn't,
is there someplace else that does?
In the subsequent pretrial memorandum.
Right. So the page, please.
That is produced in our addendum. One moment, please, Your Honor.
It's at Record Appendix, Volume 1, page 149, if that saves anyone time.
Thank you. Yes, in terms of the actual documents, there is information in the middle of the page when referring to the substance of facts and opinions that Dr. Chervin was expected to testify about. He said he will also testify as to what he learned upon physically examining and his review of Antoine's prior history and medical records as to his mental and physical health prior to his examination.
Right. So it doesn't specify the precise documents.
That's correct, Your Honor.
And it also doesn't specify anything about taking his opinion or his opinion back to 2010 or 2011. I just want to make sure I'm not missing something in the record. Right?
You're absolutely correct.
Okay.
Your Honor, but there's a reason for that. And that was explained on the record on 2/12/19 when this information first came to light. What we have here is a situation where a light bulb went off in Dr. Chervin's mind.
When did Dr. Chervin first see those scans and conclude that he was going to testify based upon them in part?
Thank you for asking the question. The day before they were disclosed to the defendants.
Which was when?
The day at trial. The day.
I'm saying 2/11/19, the day before the pretrial, 2 weeks before trial.
Nothing was said at the pretrial about scans. And it wasn't in the final pretrial produced, or the supplemental file pretrial produced by the plaintiffs on that date, the one that you just read from. No mention of scans.
There was no mention of scans because we did not have possession and control. So therefore, how could we disclose something we did not
He'd
have?
gone to the hospital to look at them.
Correct.
In fact, when he was examined on direct, he was asked, well, what did you look at to prepare the opinion? And this is Record Appendix, Volume 2, page 244. Dr. Shervin, when I engage you to be a professional witness in this case, can you please tell me what documents you first initially looked at? And he gives an answer about some reports from Mass General, reports of the Mass Eye and Ear. I went to Winchester Hospital Radiology Archives and I examined every CAT scan of the brain performed from 2011 through 2017. So Dr. Shervin is saying that those were among the initial records that he looked at. I don't understand why it wasn't disclosed even as late as the final pretrial.
It wasn't until a day or so before the final pretrial when he was so obsessed with the question of, well, how could this man be so severely demented when he came to me in 2013, that he had the reports, but he wanted to put in front of him side by side the actual scans. And it wasn't until that point when he actually got physical copies of those scans, it was within a day or so that we received them, we turned them over to the defendant.
Is there anything in the record that documents that that's the first time Dr. Shervin had seen the scans?
His own testimony at trial would be when he said he does mention that it perplexed him why this man who had worked for 3 decades as a watch repair person was unable to draw the face of a clock.
You agree that you didn't disclose until trial. Why isn't that a violation of Rule 30B? Why shouldn't we send this back?
Because, Your Honor, we could not disclose what we did not have.
I thought you said it was the day before. So I guess you could have disclosed on the day of the pretrial. You've even said that you think it did disclose, although I think Justice Wolhogen is right that it doesn't. So you knew there's a rule, this Rule 30B that says what documents does he rely on, and you didn't disclose that. Why isn't that sort of the end of the matter?
Well, Your Honor, in my point of view, they were disclosed. They were disclosed in terms of being on the stick drive, which was turned over to Attorney Kramer.
When was that turned over?
That same day.
That was turned over on 2/12/19.
And was that turned over because of a discovery request, or you just handed it to someone? What is it about? Because
that's when we first took possession and control.
I'm asking you why you gave a copy to the, I don't remember who's plaintiff and defendant here, but.
To Marcel Haddad's Attorney Kramer.
Yeah, why did you give him that? Because he had requested things? Why? I don't understand. There's no document that says, dear so-and-so, attached is a file with everything the doctor will rely on. So what was this flash drive?
This flash drive was medical records we intended to introduce at trial.
So and were they, as Justice Wolhogen suggested, did you put them in the binder of exhibits that were going to be offered into evidence?
At the time, the binder of exhibits were prepared by both parties working together. There were no scans in our possession. So they were not there, but the reports of those
scans. The reports are totally different from what he says in the scans, okay? So the scans are the critical piece of this, it seems to me. And I'm just trying to figure out whether it's okay, whether it's the Marcel's lawyer's fault, who should have looked more carefully at this flash drive, or whether you should have pointed to it and said, our expert will rely on these. That's all I'm trying to figure out.
Yes, Your Honor.
Was there a cover letter accompanying the flash drive?
Not to my knowledge, Your Honor. They appeared in court. There were communications under 23379G. I know that Attorney Woods sent copies of all the medical records he planned to use at trial in advance of trial. I know that. But these scans did not turn up until the last minute. In terms of whose obligation the discovery was, The plaintiffs sent discovery requests to Marcel because he was the only one with medical authorization to obtain the records. And Marcel, having power of attorney and healthcare proxy, obtained the records and went around to all of there was testimony from Dr. Shervin at trial that Marcel came to his office and picked up all the available records. So what you have is a situation where we combed through the discovery and elicited the ones we would use at trial. The ones we had, we certainly produced. We did not have the scans until the last moment because it wasn't, you can't control the epiphany.
Though, right? You have to point to them, don't you? Doesn't Rule 30B mean when you know about them, you have to point to them? Am I wrong about that?
You're absolutely correct, Your Honor. And as soon as we knew, as soon as we had possession and control of those scans, they were delivered to the defendant, who, I might add, not only neglected to review the medical records he had his client deliver to Attorney Wood's office with no regular Rule 34 documentation whatsoever, no organization whatsoever, but he also did. So in other words, Attorney Kramer did not review discovery that left his office, nor did he review discovery that came into his office. And now he claims unfair surprise.
Can I ask you, oh, your time is growing short now. Can I ask you about the rebuttal of the presumption of testamentary capacity? What rebutted that presumption?
Certainly, Your Honor. We have the testimony of Dr. Shervin, which was able to do a retrograde analysis based on the degree of brain atrophy that he saw in this man's brain in 2010 of March. He was able to let us know the condition of his deteriorated brain at the time he signed the documents in July of 2011. In addition, we have the testimony of Teresa Shammy, his dear
But there was nothing that linked that testimony explicitly to testamentary capacity.
That's correct. However, he talks about shriveled brain cells.
Right, and can a judge make that link without expert testimony?
She did have expert testimony.
I don't, nobody, you know, I don't know. I'm not a doctor. I don't think a lay person can know how much Alzheimer's or how Alzheimer's and at what point, and whether that's the same on every day, you know, affects testamentary capacity. And that's the link that I'm struggling with here. You certainly put in evidence that the decedent had Alzheimer's, some progressive form of Alzheimer's, and 2010 was maybe the earliest point of it. I didn't see anything, any expert evidence that would take that testimony to establish by a preponderance of the evidence that there was a lack of testamentary capacity. So that's where I'm struggling. How does the judge do that when the judge is not a doctor?
Well, respectfully, Your Honor, I disagree. There was very specific testimony concerning the areas of the brain that control cognitive function. And you'll see throughout both the medical reports, consistent with Dr. Shervin's testimony, that in Antoine's case, his brain tissue had shrunk and his ventricle, the ventricle area of the brain had increased. And that's what happens when the active...
Does memory loss, right? There's some memory loss. It's clear. There's an email from Marcel about some memory loss, as lots of older people have and Alzheimer's patients always have. That doesn't necessarily mean that he didn't have testamentary capacity, that his short-term memory was damaged, does it?
Right, but there were other correlating things. Dr. Shervin discussed this. It's not just the test. You correlate it with the cognitive functions, and that was shown by the emails.
All evidence of cognitive functions was that no one even bothered to test him for cognitive functions when he was hospitalized at that time. There was no sign of it, as far as I can tell.
Actually, Dr. Shervin went a bit further, and he correlated the number of falls and broken bones by Antoine to be significant as a sign and symptom of Alzheimer's specifically, given those 10 factors of Alzheimer's disease that we saw. He correlated that all to the mental decline, the cognitive function, the actual shriveling of the hippocampus in the brain.
What is
All
the
of that went
definition?
to showing.
Yeah, what is the definition of testamentary capacity?
It is whether or not the testator had the necessary ability to understand his bounty, the capacity to understand what he had for assets and to whom he was giving them to.
I don't even know that he needs to understand his assets. He just needs to understand who he wishes to be the recipient.
Right, and we have an overwhelming language problem here.
And that's a different thing. The question here is how close or how far is Dr. Shervin's testimony to that test? But your time is out,
think it's,
so maybe we need to leave that for another.
Your time has expired. We appreciate the arguments. It's an incredibly interesting and difficult case, and it presents issues that are likely to recur. So we appreciate counsel's assistance with this.
Okay, we are live. We are recording and streaming.
Welcome to the Appeals Court. Good afternoon. This is our final case of the morning. We are in video conference rather than live due to the pandemic. I would remind counsel that the audio and video are both streaming live and will be archived and available to the public for viewing later. And you should act at all times as though your camera and microphone are on, because they may be. Our rules are the same as in person, 15 minutes aside. There is no rebuttal. The next case that we are hearing is Atlantic Resort Development versus Current Management Services, Inc., number 19-1607. And I believe we will hear first from Mr. Carr.
Good afternoon, Your Honors. May it please the court, I represent Mr. William Kern in this matter as appellee. And this is on appeal from a judgment, an order of Judge Rufo after it came back from this court to permit veil piercing against Mr. Kern personally, to hold him personally liable for the corporate debt of in-season management, which was deemed to be the successor to Kern Management Services. So this appeal, it already came up once, but this is limited to Mr. Kern's now personal liability for this judgment, and deriving from a judgment that was entered against CMS in 2012. And this case, Your Honors, for veil piercing is a first-pronged veil piercing case under the My Bread case. That means that that Atlantic Resort Development had to prove and asserted that Mr. Curran individually exercised pervasive and active control, and therefore Atlantic Resort also had to show some fraudulent or injurious consequence. And I'm reading from the Supreme Judicial Court's case in Scott, and Your Honors, the appeals court decision in OMV Associates as well picked up on that same language when this court upheld the jury instructions. I think it was Judge Botsford was the trial judge in that case with respect to the veil piercing claim. And so
my
that's
reading of those, I'm sorry to interrupt, but my reading of those cases, and I've looked back at where the prongs, well, not the prongs, where the 12-part test comes from. And of course, one of the factors in the 12-part test is fraud. So it seemed odd to me that there would be a gateway prong that includes fraud, and then you'd look at fraud. And it appears to me that the 12-factor test is really what we are looking at here. And that if you whatever fail or pass, whichever it is, the 12-factor tests, such that equitably a court can conclude that the veil should be pierced, that the first two things mentioned by the court really in My Bread baking are the conclusions that the court is reaching. And it just seems to me that the question is, there's a 12-factor test and is it met? Do you disagree with that?
Your Honor, I disagree from this perspective. I'm not fighting the findings below. Let's be clear on the court's findings of fact with respect to the 12 factors. And I concur that those 12 factors are what the courts look at with respect to the prongs, both of them, frankly, on both prongs, the first and the second. But the first prong has, in addition to those 12 factors, has the requirement, and again, I cite to the court in OMV, which cites Scott and Arendelle, all those cases that says that you must have, you must also show injurious consequence. And the courts have said fraud is an injurious consequence, and it can be other things, but there's a separate element of the first prong, as I would indicate, Your Honor. And all the cases are absolutely dead clear on the fact that you have to have that additional, that added evidence of injurious consequence.
So are you saying by consequence, do you mean causation? So not only do the 12 factors or some adequate mix of them have to be present, but that they have to have led to the whatever injury is supposedly justifying piercing the veil?
That's correct, Your Honor. In fact, that's right from the Scott case.
Let's look at a very common kind of veil piercing case. Some guy starts a business from his home and he bothers to go and incorporate, and he gets a checkbook, but half the time he uses his home checkbook, just his personal checkbook, and half the time not. And sometimes when he signs contracts, he just puts his name on them, and sometimes he uses the corporate name. And he just doesn't pay any attention to the corporate form himself. And then eventually someone has a judgment against the corporation, and they say, and I'd like to go after him too, because he didn't pay attention to the corporate form, and the corporation is undercapitalized. I'm not going to get anything from it. And there's no fraud. There's probably not even any intentional wrongdoing. There's just injury and failure to really treat these corporate forms as legitimate. That's got to be an okay circumstance for veil piercing, right?
That may prove up the 12 factors, and I agree that you don't have to hit all 12. I'm not saying that. However,
yeah.
But Your Honor, I'm all the cases that have been decided in this realm, this court, the appeals court, and the SJC have all required the additional element of fraudulent or harmful consequence from the intercorporate relationship.
Yes, the harmful consequence in my example is they didn't pay close attention to the corporate form, and I was injured by the corporate entity or the individual, whatever the corporate entity. But this guy was not being scrupulous about drawing the line, not intentionally. And so that's my injury. My injury is I was hurt by a corporation that isn't really separate. It's really a mishmash with the guy himself. Surely that is a veil piercing case, right? Or no?
I disagree from this, Your Honor, that if there's evidence that all of that stuff that you just related caused the inability to make the payment to you, then I would say, yes, there's sufficient evidence to make.
No, it didn't cause anything. The corporation
have to have
causation with $8, and the guy himself is worth $40 million. And he played fast and loose, and now they're saying, look, he didn't pay attention to this. Why do I have to? Shouldn't I be able to go after him?
I'm so sorry. I apologize.
No, please.
Because the Supreme Judicial Court has said the injured party must show some connection between its injury and the parent's improper manner of doing business. Without that connection, even when the parent exercises domination and control over the subsidiary, corporate separateness will be recognized. That's why, Your Honor. And all the cases, including OMV, have said that. Arendelle said that unreported. And let me go directly to the point that you've made and that they've argued, that failure or inability to collect a judgment debt is injurious consequence, because that's really what this comes down to in my estimation. And Justice Cass of this court in Evans, which ARD relies on heavily, and the Scott case did as well, for that, the finagling line that Justice Cass was known for. This is what he said with respect to this argument at page 737 and 738. And this is what he said on this point. The risk that a defendant without fraud and in the normal course of business operations may become unable to answer to a judgment is inherent in any civil litigation. Judge Cass then went on to say there's these other remedies that a creditor can try for. And one of the remedies they could try for, Your Honors, was a fraudulent conveyance. And in this case, that's exactly what we had. We had a fraudulent conveyance.
I'm not talking about fraud, though. I'm talking about failure to adhere to the corporate form.
It's not enough.
I went to law school a long time ago, but my recollection, and from cases I've heard since then, is that there are circumstances where it's not with fraudulent intent, it's with negligent intent or indifference, you know, knowledgeable, whatever, reckless indifference, knowledgeable, intentional indifference. The person just thinks of all these things as his or her, you know, just these are some buckets with some money in them. I use them all the time for all different things.
That may be how Your Honor reads the cases. I with all respect, I don't. And I'm citing
I'll have
again,
to look with more care. It's
I'm
clear.
I'm citing the OMV. I'm reading OMV. After the court decided that the instructions were proper to include those additional prongs, the court said this: first, there is no evidence that Mirror Image, which was the defendant, the veil-piercing focus in that case, used its intercorporate relationship with Clearway to perpetrate fraud. That's the first thing the court got to. It went through and it says, and again, nor was there evidence sufficient to causally link the defendant's arguably pervasive control to OMV's injury, and certainly not in a manner that could be found grossly inequitable.
Mr. Carr,
Kraft v.
what
Kane,
is the OMV case? I don't see it cited in the tables of authorities of any of the briefs.
It's not, Your Honor. I would say that it's not in there. I cited to Arendelle, which cites to OMV, and I cited to Scott as well. But this case.
What's the site for OMV?
Yes, it's 82 Mass App Court 561 at 2012. I'm sorry, 2012. And it is cited in the Genentech versus Arendelle management case, which is the unreported decision, which I did cite to.
So I take it your position is that fraud and a detriment to the creditor are not simply factors, but are required showings before the veil can be pierced, the corporate veil can be pierced.
Yes, Your Honor. My position is that fraud is one of the 12 factors that a court can look at from determining pervasive control and active control under that first piece of the element. The second element of what I call a first prong my bread case, which is the pervasive control as opposed to the confused commingling, which is a different issue. Then there's no confused commingling claim here at any point. So this is a first prong case, C. Scott. You have to, in addition to, as an essential element to veil piercing, a plaintiff must prove those 12, and they don't have to be all 12. It can be 2, it just may be enough.
And how can they be essential? They're factors. As opposed to, if you don't need to prove all 12, then they can't be elements. They must be factors, no?
Those are elements of, I'm sorry, let me restate. The 12 are factors in the first element of pervasive and active control. That's what the courts have said. The second element of that, well, I say the first prong Cumberland my bread baking case, the second piece of it, per the instructions of the court, is that they must be active and pervasive control. Those are the factors, the 12 factors to go to that. And then the fact finder must show or find that it controlled the related business entities with fraudulent or harmful consequence from that relationship.
Okay, so I take it what you're saying, if I understand you correctly, is you're not contesting that your client had pervasive and active control.
Correct.
Right? You're conceding that first prong, and because in your view, even fraud may or may not be necessary. It could be present, but it's not required to prove that. So you're not contesting that your client had pervasive and active control of the various entities. What you're saying is that control did not result in a fraudulent adverse consequence, or whatever the language is, to the to the Atlantic Resort.
Right, and in this case, that's exactly right, Your Honor. I'm not contesting pervasive and active control prong of the first prong of that. I'm saying there's no evidence to link, and specifically here where the judge found after the trial that this guarantee and agreement was evidence of an inability to collect. So what the court said below was the harm as a result of this pervasive control was the inability to collect the judgment. No court has ever found that the inability or the delayed ability to collect a money judgment rises to the level of gross inequity to permit or injurious consequence or fraud, because it all rises, the harm is the fraud.
All right, but
no court has ever held that before, Your Honors. In
That
this
seemed to me that could be a factual question, right? So if you take years of steps that you keep trying to shelter or remove, if you take many steps or continuing steps to ensure that a judgment is uncollectible, then maybe that would satisfy the test.
No, Your Honor, it does not, because Justice Cass said the inability to collect is not inequitable conduct under this veil-piercing rubric.
Well,
That's
but we
not.
have cases since then, and I'm looking at Scott versus NG. It certainly distinguishes, if you're going to treat these as prongs, it seems to suggest that fraud or injury on the one hand, or confused intermingling on another are enough.
No, Your Honor, but that's not correct, because there's two separate prongs. One is the pervasive control prong, one, and the other one is confused intermingling. And Scott says those are two separate theories under veil piercing. Here, the only thing that went to trial was the pervasive control. And that's what Your Honor said in Arendelle. The only issue at trial, or the only prong it was decided, was the pervasive control prong. You don't even look at the commingling prong.
Mr. Carr, let me ask this. The findings on the 6DB included thin capitalization. Mr. Curran used CMS and IMI to fund other Curran-related entities, his personal interests, and family expenses. Could not that have contributed to ARD's inability to collect from IMI and therefore been a cause of the injury that would justify piercing the veil?
Not here, Your Honor, because the judge already below, after the bench trial, found that all of the operations of the entities and the moving of the assets and the closing of the book accounts were all done in the ordinary course of business and consistent with the shutting down of the operations of the entities. So that could not be.
We're talking about causation. Why couldn't the thin capitalization of IMI contribute to ARD's inability to collect, just as the giving of the security interest to resort funding also contributed?
I guess hypothetically, to answer you, that's a hypothetical question, because the judge did not find that. The judge only found that the security agreement was the activity of creating a situation, Your Honor. The injury that caused was the inability to collect the debt. That's what and there's no evidence that it didn't make it, that it made it impossible to collect the debt. They may have delayed it, arguably, but Justice Cass said that's not even enough. But Your Honor, so there's no connectivity, and there's got to be direct, and it's their burden, not mine, to prove that the way that Mr. Curran ran the companies, which I'm not contesting, Your Honor, to Your Honor's point, that I'm not contesting the pervasive and active control. What I'm saying is that stuff did not cause ARD not to be able to collect its judgment. And the fact of the matter is, they said all of that stuff was fraudulent conveyance activity, was unfair deceptive conduct in violation 93, and the court said no, it wasn't deceptive, it wasn't fraudulent, it wasn't unfair, and that's my argument.
An excellent argument. Thank you very much. Your time has expired.
I
If there are
appreciate
no
it.
further questions, we will hear now from your brother.
Thank you, Your Honor. Good afternoon. My name is Daniel Laufer, and I represent the plaintiff appellee in this case. I believe that my brother's argument is a classic case of putting the cart in front of the horse. What he has done here is he has confused two different findings by the lower court. The first finding, he was absolutely correct, was that when Mr. Curran utilized his pervasive control over his corporations to empty Kern Management Services of all its money. That was entirely proper. It was done in proper bookkeeping, and Mr. Kern observed the proper formalities. What we're talking about is a post-judgment manipulation of the facts and the assets in order to deprive my client of an ability to collect from in-seasons management. That's what's at the heart of this. In-seasons management and Mr. Kern were not faultless, blameless, or did not engage in finagling, because they did. First of all, during the trial, they introduced evidence, because this was limited to a question of whether or not the transfer from assets from Kern Management Services to in-seasons management was correct. They limited the information to the calendar tax year of 2012. And at that point, Kern Management Services had 3.7
Mr. Laufer, I don't view the judge as having made a finding of failure to disclose in discovery or connecting that to the veil piercing. So the question is, how did any of my bread baking factors contribute to ARD's inability to collect from IMI?
10 of them did, Your Honor, because what Mr. Kern did, and this was found by the trial judge in connection with his running of the operation prior to us discovering what had happened. Number one, he was able to move assets in and out of different corporations by back charging them. In-seasons management provided services to the other Kern related companies. He could back charge them after the end of the year to make sure Kern Management Services never lost money. Number two, he could create and he could forgive debt so that he could move assets among all the different corporations. That is precisely what he did after 2012. I'd like to direct the court's attention to the final order issued by the trial court. And what he said was that considering the totality of these factors, this court finds that piercing the corporate veil between Kern Management Services, in-seasons management, and Kern individually is necessary to prevent the inequitable and unjust result of Atlantic Resort Development's inability to collect the underlying judgment. He is finding there that an equitable remedy, and that's all that veil piercing is, it's not a separate cause of action, was necessary to correct what had happened here. If the judge believed, as we did, that in-seasons management had enough assets to satisfy the judgment, hence we had a legal remedy. What he was saying was it was inequitable and unjust because Mr. Kern had taken that money out of in-seasons management. It had less than $1 million worth of assets as of the end of 2017. And
did he take it out of IMI, or did he give a security interest in it to resort funding, which was an unrelated
two
entity?
things, Your Honor. He took $1,284,000 out of the company in cash. Number two.
When was that?
That was during the period between 2013 and 2017, after all the evidence that had been presented in court. We didn't know about
the evidence in court in which action?
In the action against IMI, when successor liability was imposed.
Okay.
We had no evidence past December 31st of 2012. At that point in time, in-seasons management had $3.7 million of assets, and it had the ability to manipulate revenue so that it never lost money.
But did that money go into his pocket, or did it go to some other Kern-controlled entity?
Both, Your Honor. As noted in the balance sheets that we were given, $1,284,000 in cash went directly into Mr. Kern's pocket. Another $1.6 million was reconfigured by forgiving debt, back charging, and doing other things, and moved to other Kern entities.
So why can't you pierce the veil and go after those other entities rather than going after Mr. Kern individually?
Because Mr. Kern has the ability to, this is exactly what the court found. We start that process, he's going to move stuff again. And I'm going to, this is his whole.
Well, wait. So are you saying that the finding or the statement that it would be unjust otherwise implies that Mr. Kern has used his pervasive control of these entities, or at least of IMI, let's leave Kern out of IMI,
yes,
in order to deliberately, in order to prevent collection of a proper judgment. You're saying that that's, even though those words don't appear in terms in the judge's order, that by saying it's unjust, it wouldn't be unjust if it was just the normal course of business. So he must be saying, since it's inequitable and unjust, he must be saying, because he has played fast and loose with the corporate form in order to do this wrong.
Correct. And on top of that, as Your Honor mentioned before, then they put a lien on all these assets, and the basis for the lien was improper, because the basis
that hasn't been. Maybe I'm wrong. I don't think that's exactly been litigated, right? I mean, all right. So it's true that rather than whoever the security interest holder is coming to IMI and saying, "Hey, IMI, we see you're in default. Here's our lien." Immediately, IMI goes to the creditor and says, "Listen, you might want to put a lien on these assets. P.S. We still do business with you, and we want to make sure you get the money, not ARD." Right? But the judge didn't say that hasn't been. I mean, that hasn't been found, right?
But Your Honor, it can be inferred because the document.
But if the judge, was it inferred by the judge? We don't get to infer it, right? No. It's fact.
What he inferred is that a lien had been given that precluded collection.
In order to preclude collection.
But how is giving the lien a consequence or causally related to any of the 12 my bread baking factors?
It is pervasive control, in my view, Your Honor, it is pervasive control. There was a clear indication that this was an improper lien for the following reason. The underlying documents, the security agreement, said that the only time you have a default is if a judgment is issued. And
so,
it is not sustained.
Yeah, and they weren't in default because the appeal period had stayed the collection of the judgment. So there could be a question raised about whether there was a need to give this lien. But doesn't that go to the question of whether the lien could be voided somehow, rather than whether there's a need to pierce the veil and hold Mr. Curran individually liable?
And that goes to perhaps my final point, Your Honor, and it's this. That lien did make it impossible for my client to collect from in-seasons management. This is not an isolated act. Mr. Curran was found guilty of breaching his fiduciary duty and intentionally violating Mass General Law 93A between 2003 and 2005 and cost my client $792,400, which he still has today. We couldn't get a judgment against him because of the statute of limitations, but that does not remove the action or absolve Mr. Curran of what he did.
Can I ask you a question? Are you agreeing with Attorney Carr that you have to show intentional wrongdoing causing harm? Or is your position that if this playing fast and loose caused harm, that's good enough?
It's the latter, Your Honor. It's if these actions have caused harm, that's sufficient. I was merely pointing out when I said that the cart was before the horse, Mr. Carr assumed that there had been no fraud or finagling.
And what do you do with Mr. Carr's reading of OVM to say there has to be intent? I'm not saying that's a right reading. I'm not saying OVM is right. I have no idea. I've just looked at OVM for the first time, frankly, while we're having argument, but go ahead.
I have not read the case, so I would hesitate to respond to something I've looked at, but I would say, Your Honor, that in the event that it is required, I believe that the trial court made that as a part of his finding that it was inequitable and unjust to allow this particular judgment not to be collected.
Where will we find the finding that you mentioned about Mr. Curran having taken $1.2 million out of IMI and put it in his own pocket?
If you can give me one moment, Your Honor, I believe it is in the first volume. It 130. Yes, if you look at volume 1, page 130, there is a line item that shows distributions W. Curran, $1,258,530. And then I believe there is a second one, yes, on page 133.
I'm still looking at page
133?
133. If you go up from the bottom, 5 lines from the bottom of page 133, it states distributions, William Curran, $1,284,518.
Is there a finding of fact about that was for nothing, that was, whatever, just taking some money out of his company?
That's what a distribution is, Your Honor.
Or was there something improper about it? I mean, who's the shareholder?
He is a 100% shareholder. And in normal course of events, whatever he wishes to do with his money is his business. In the context of telling a court that there's $3.7 million in assets in the company, when he knew full well at the time that evidence was presented that there was less than $1 million in the company.
Okay, so where is the finding that he told the court or somebody that there was over 3 million there when in fact there was only
because they provided the court with tax returns for the year 2012, and that was what it was agreed upon. And that $3.7 million of assets was buttressed by the testimony of the chief financial officer and the key bookkeeper to the effect that In Seasons Management not only had the ability, but had in fact back-charged other current entities hundreds of thousands of dollars in order to ensure that Curran Management Services never lost a cent.
Am I right that there are findings that he used IMI for himself and his family?
Absolutely, Your Honor.
Yeah.
He used it to pay for family expenses. He used it to fund his other corporations. He used it to
how much was used for family expenses?
Pardon me?
How much was used for family expenses?
I don't remember. I think over the course of the years, it was a couple $100,000. So somewhere in that neighborhood, he was paying, I believe, a tax debt for one of his family members.
Was there a finding made about that?
Absolutely, Your Honor.
Where is that?
I don't have it, but the trial court found that In Seasons Management was used to fund partner legal expenses, Mr. Curran's legal expenses, his personal expenses, and to fund his other companies.
I thought I saw that, but we'll have to look again.
So you say in your brief that Mr. Curran is trying to force ARD to collect through other litigation against IMI, the lender, who I assume you mean Resort Fundings, and Mr. Curran individually. What other litigation or what other claim are you referring to that could be brought instead of piercing the veil and going after Mr. Curran individually?
We'd have to start the whole process again, and we'd have to start with fraudulent transfers and the whole thing.
But that is an equitable remedy that's available to you, correct?
It is a remedy that's available, but if you look at the Boston Marathon case, what the court said there was equitable relief granted in the form of a prejudgment injunction. But equitable relief is warranted when it is going to make collecting infinitely more expensive and difficult. And that's exactly what's going to happen here. If the court has no further questions, I would refer to my submission.
Well, we're very grateful to both of you, counsel, for excellent, really top flight arguments. Thank you very, very much. It's very helpful to us. Your time has just about expired, so